It,
Yes.
my lord, for to be mentioned today, my lord, it has not been listed tomorrow.
To be mentioned, why?
My lord, call for the report from the district judge of South Chobbish Pargana, my lord, Mr. Srivastava mentioned yesterday, my lord. Item on today's item number 245.
245.
Yesterday it was 237, my lord.
245. Mongolbar din to be mentioned.
My
Yes.
My lord, I may be permitted to mention one item, my lord. My senior Mr. Gopala Binukumar appears in that matter.
Extension of interim order.
My lord, there is an we are seeking for an interim order.
Bring him.
My lord,
What time, my lord?
1 p.m.
there is a PROCEEDINGS matter, my lord. There is a PROCEEDINGS matter which is listed before court number 3. 2 days ago, it was mentioned. So it's coming up in the supplementary list. My lord, there is an urgency. My lord, takes this matter today. It's listed before the court number 3. File is lying with the court number 3.
What is this? What is the urgency?
So the urgency is, Lordship, sanction plan has been issued by the Portland Municipal Council. Despite that, an order has been passed by the same council without hearing me and by an authority who has not been vested with the power to pass such order under the municipal regulation, Andaman municipal regulation. So kindly consider it, Lordship.
Item number?
Lordship, it's in the court number 3, supplementary list, Port Blair matter. Only one matter is listed.
Port Blair matter.
I'm grateful.
Who is
My
appealing?
lord, I may be permitted to mention one item, my lord. Port Blair item.
Mr. Divedi, I put in notice, Lordship. He would be appearing again. I've sent a notice.
কটার সময় রাখবো? দুটোর সময় তো এটা আছে, তাহলে ডিসপার্ট করতে হবে তো।
I'm coming to know, Lordship, after 2, there will not be any court. Lord, I'm not just bothering my Lord, but can it taken out 2? I understand. I've been staying here for the last 2-3 days. I could get the matter listed.
12:30 করে দিন।
I'm grateful.
12:30 একটা সাপ্লিমেন্টারি লিস্ট পাবলিশ করুন।
My lord, I may be permitted to mention one item, my lord. Port Blair item. My senior Mr. Gopala Binukumar appears in that matter. There is an extreme urgency, my lord. We are seeking for an ad interim order. Can it be fixed in the second half, my lord, today?
Not second. What is the item? Which item?
Not in the list, my lord.
Not in the, just to be, when have you filed?
My lord, we have filed last week.
So it will appear Tuesday.
My lord, there is an extreme urgency. We are seeking for an ad interim order, my lord. One title appeal is pending before.
Tuesday it will appear. Please hand over the slip. Tuesday it will appear.
Compelling circumstances, I am, my lord.
The Port Blair matter which has been mentioned by Mr. Jaipal, my lord, I am for the respondent for Port Blair Municipal Corporation, my lord.
Yes, it will. কটায় বললাম ওটা পোর্ট ব্লেয়ারটা? 12:30. 12:30 it will be taken up.
Grateful.
Compelling circumstances, I am mentioning, I wants to move a matter, my lord, on my lord 13th, my lord. 14th is the date fixed for my lord argument. But my DW has been closed on my lord 20.
Which item?
My lord, this is not in the list, my lord. I'm praying leave to move it, my lord. My lord,
It will appear.
my lord, 14th is the date, my lord. 13th.
Maybe.
Up to 12, my lord, the holiday, my lord.
Maybe.
My lord, 13th, any time, my lord, kindly. My lord, 13th, any time, my lord. At
File it, give in the presentation from the date, it will appear on 13th.
13th, if not, my lord, in that event, my lord, the entire, my lord.
Please file, give the listing date as on 13th, then tell me if it is not listed.
My lord, very well, very well. Grateful.
I have updated yesterday, my lord. Determination of Honorable Justice Gorankant, my lord, courtroom number 3, my lord. My lord, under compelling circumstances, I am mentioning, my lord, the Kolkata Municipal Corporation being the respondent number 7, my lord, the executive engineer, my lord, issued a letter, my lord, intimating the private respondent number 7, my lord, to demolish my shop, my lord, without affording any opportunity of hearing anything. On the basis of that letter, my lord, now the private respondent with lever and hammer and Manson, my lord, is standing, my lord, near the shop room of the petitioner, my lord.
এটাকে দিয়ে দিন একসঙ্গে। No, file it, it will appear.
My lord, since the determination of courtroom number 3, my lord.
File it, it will appear. It cannot be taken up today.
No, not today, my lord. Kindly any date, my lord. If leave
It will appear. If file it, give the date, it will appear before. So I have only determination for today.
for today,
Why do you want leave? Yes, file it.
so today at 2, my lord, we will serve.
No. Today it's not possible. দিয়ে দিন।
my lord,
হ্যাঁ, দিয়ে দিন। File it.
my lord, maybe
Yes.
my lord, someone.
Yesterday, your lordship grant leave to move an urgent motion. Matters appear 47.
Not appearing.
47, my lord.
Yes.
My lord. Otherwise, it will be.
Sir, it's very difficult. I do not know. Another urgent determination has been given. I do not know.
But mine is 46.
My lord,
Who has assembled?
Court table, my lord, and the advocates already has.
144 is there, Mr. Sen. 144 is there.
My lord, may I?
46, my lord.
46.
46 and
And Mr. Rai, your item?
47. Next. Yesterday.
46, 47.
May I be permitted to
Yes,
mention?
my lord.
Sorry about it. Come at 12. 5 minutes past 12.
Yes, yes, yes.
If it is not meet in the meantime.
My lord, may
My lord, without 48 hours, my lord, working days, my lord, working hours, without, department will not take, my lord, the filing, my lord. Well, kindly
Leave to file with the date of listing on 13th.
get.
We leave the bench.
My lord, may I be permitted to mention one matter, my lord, for correction of order?
Hand over the slip.
My lord, this summons was not served. The date is 5th of June. My lord, this is item number 1 on monthly list. The extreme urgent. My lord.
Mentioned yesterday.
Yes, my lord.
Don't mention today.
Permit to
Please
mention-
don't repeat. Every day if you go on mentioning, it's difficult to proceed with the
My
list.
lord, can I keep it on
You have
13?
mentioned, you have handed over the slip.
Yes, my
I've
lord.
looked at the slip.
Yes, my lord.
Again, you are mentioning.
Your lordship, may I be permitted
My
to
lord, can I
mention?
keep it
your
on
lordship?
13, my lord?
That I will consider.
My lord.
I've looked at your slip. I've
I'm
given some directions.
I'm grateful,
Please
sir.
don't repeat mentioning the same matter times and again.
I'm
Then I will have to release that.
Your lordship, this is for release of the matter, your lordship. I had mentioned it yesterday, your lordship.
Yes, what, it is appearing in the list?
Yes, you're in the monthly, combined monthly list, your lordship.
আসেনি ওটা? জানেননি? Tuesday.
May I permit to mention item number 130, your lordship, the learned court below has fixed 16th of May for argument. Your lordship.
16th of May.
Your lordship, kindly fix it.
Yes,
Your
not now, yes.
lordship, may I permit to mention, mentioning for inclusion.
16th of May, madam. So today we are on 8th only. Please wait.
Lordship, may I permitted to mentioning for inclusion, the matter.
Today, yes, please call the list.
May I, my lord, hand? May I seek leave to move a matter, my lord, today at 12 p.m., my lord?
Yes,
But the urgency is this, my lord, the urgency is this, my lord, the corporation has invoked section 37 of the KMC Act. My lord, where, my lord, I am a owner of a flat. Now, my lord, I was doing a renovation work in respect of my flat. Now, suddenly, my lord, they have come and given a notice under section 37. Now, 37 is an exclusive power which is given to the mayor in case of emergency when there is an.
when the
But may
notice,
I come back at 12:30?
Mr.
Well, notice was given last week, but it is dated last week. We have received it yesterday, my lord. Well, we have received it yesterday.
Maybe,
Well,
so,
may I come back at 12:30?
no.
May I come back at 12:30? Well, I am an owner of a flat. It is not a case of unauthorized construction, my lord.
You can wait.
Well, it is. Not been served, my lord.
What?
A partial demolition have already been executed. We are appearing within 3 to 4 days.
Which matter, Mr. Chakraborty's?
This matter, my lord.
Yes.
Any day in the next week, my lord.
Any day in the next week, I only have determination for today.
My lord,
Please mention.
only leave, my lord, for urgent listing and moving. I'm seeking leave, my lord.
Why do you need, if you want to move it next week, why do you want leave?
No, the 4 days will be a holiday, my lord. In that event, anyhow, I cannot.
Short service, leave to file with short service.
May I permitted to mention?
May I sleep, my lord, for upgradation, your lordship, my lord, will consider it later. My lord, for upgradation, my lord, may I also?
Lordship,
Yesterday you have listed.
e-auction notice has been issued, lordship. It is to be held on 30th of May, lordship. My account has been declared NPA, lordship.
Yes.
I'm-
See, you have filed the civil division
Lordship, it's a writ petition, lordship. I'm mentioning.
petition.
Yes, lordship. I'm
You don't have determination over it.
lordship, group 9 matters, lordship.
Group 9.
Yes, lordship.
Group 9 টা কার আছে? আমার group 9, I have determination over group 9.
Yes, lordship, residuary matters.
No, it's
Lordship,
the determination of Justice Kant.
no, lordship, your lordship, distributor.
I do not have group 9 determination.
My lord, may I be permitted to mention with urgent matter, my lord? This is matter related to tender, my lord. E-auction, NI2 was issued 14, my lord.
What do you want? It's in the list.
Yesterday, the tender was scheduled, my lord. The writ petitioner hearing, my lord, he was
This
qualified.
is the matter pertaining to which determination?
Honorable Justice, Honorable Gaurang Kant, my lord.
Yes. You have filed the writ petition.
Filed it, my lord. I have served the copy upon the respondent authority, my lord.
Yes.
My lord, 7th, yesterday it was tender.
What is the date of tender?
Yesterday was 7th of May, my lord.
So it has happened.
But the result has not come out, my lord. My result has not come out yet, my lord. Tender was scheduled on yesterday, my lord.
Yes, the tender was conducted. No,
My lord, for release your,
no urgency.
for release of section 26 application.
26 or 24?
24 application.
Please hand over the seat. Call the list.
Another mentioning your lordship for upgradation, your lordship.
Today, don't mention upgradation for today. Yes, call the list.
My lord, for the release of the section 24.
Section
The release of
24,
the section.
hand over the slip. Yes, call the list.
I'm for the petition, section 24.
Section
Release.
24. Due Section 24, same order. Next,
3,
next,
4,
4 की section 24. देखिए, section 24. देखिए,
I have not been served. I am for the opposite party. My lord, another connecting application was there. Well, let that matter be taxed. I don't know what is there. I have not been served.
Lordship, in item number 4, I beg for the petitioner and my application is transfer application.
This application
I
may be
do not have determination. Yes, next.
I
My lord, in this matter, my lord, I had mentioned yesterday,
That matter, where is the other side?
I'm for the opposite party, your lordship.
Yes,
led by Ms.
who is for the petitioner?
I am led by Mr. Dr. Bara.
Yes, Mr. Chottapada, what-
Mala, I am for the,
Nobody is willing to act as a special officer in your matter.
Mala, I am the mother, Mala, then visitation rights may be continued because Mala, that was the father's, Mala, wish that the special officer might be there, Mala. Otherwise, lordship, I'll carry with the visitation, Mala. If in the meantime, if some.
Madam, can you do for this week so that I'm keeping it in the next week? What will be the next day in the next week?
For Tuesday, my lord.
Tuesday. So please continue up to Tuesday. So I'm at a Wednesday. rekhe din. List this matter under the same heading. Yes.
Grateful, your lordship.
I'm done.
Yes,
And Mr. Chottapada, you can find out any alternative if someone
Mala, I'm
he
trying.
has difficulty only with regard to the distance.
Distance.
So if someone near, because it's far, because the visitation is at where?
Mukundapur, my
Yeah.
Mukundapur.
Kundapur, and she's
Mala.
staying at Beala, it's far off.
Mala, if cab fare can be, Mala, given by the father, Mala, then it can be as per
My
my,
lord, we are already bearing all the expenses since
Mala,
the inception.
it's my husband's choice, Mala, that he wants a special officer.
Please see if anyone near the locality can be found. That would be, I think,
Mala, I'm trying, man, I'm trying.
Grateful, your lordship.
section 24.
same order next. Same order, money released.
7,
Dekhi file din. Same order next.
8,
8,
your lordship.
Section 24, same order next.
9,
9 is.
Sir, I am the petitioner person.
Yes.
Sir, I have filed this divisional application of number 274/25 against the order passed on 6th August 24. Sir, here the trial court is giving pressure to continue a fraud match suit of number 73/16 that was filed by Shomi and Viswas at Alipur Court. Sir, he after filing, he just left that copy at my house, but that was not received.
What is the order and the challenge?
Sir, I am not the respondent. You see, later I found that he has written this. You see the. You open now page number 12, sir. So 13. You see the copy. You see what he is writing. You see, Sri Shomiran Vishwa, son of Prabhakar Vishwa.
What is the order on the challenge?
give the residence of a sister residing at and versus Srimati Paul Podar. I am not the sir Paul Podar. Sir, after receiving the copy, I appeared before the High Court to transfer the case. That time I did not, but I did not see that the responding the Paul Podar, and so he had expressed his address in a peculiar way. Then okay, then and I filed transfer case of number 2225 by 17. Okay, but later I found that he has it is a fraud case. That time I did not take any further process to transfer the case. What happened? You see, in 2020, or sir, you open page number 2025, sir. Have you opened? You see two appearances. They secretly transferred the case filed by me and went to have the ex parte order. On 22/11/2021 hearing, they went to have the ex parte order. And there on that day, I appeared before the court. Sri Judge Supratim Dasgupta was present there. That time seeing me, they escaped from the court. I was left in the court. That time, Sri Supratim Dasgupta sir told that he will dismiss the case, and he again fixed the next date on 18/2/2002 for hearing to dismiss the case verbally. That case was pending for hearing to dismiss the case. Later, sir, on when he was Sri Supratim Dasgupta was in charge. Later, the actual district judge Sri Ashutosh Singh came in that court, and that time he did not know nothing. That time, what happened? I employed a advocate. And two advocates did not hold the hearing, sir. On 16/9/22, they both did not hold the hearing, and they both transferred the case to the another court, which was fixed for a hearing for a dismissal.
Petitioner is directed to serve a copy. Yes, call the next matter.
Item
10.
is also section 24.
Section 24, same order for want of determination. Next,
11,
My lord, court section 24.
same order.
12,
12 to the key. Pass over. Yes. Please call this advocate. There's a mobile number. Pass over. Please call the learned advocate. In the cost title, there's a mobile number. Ask him to come. Yes, next.
13,
Extension for interim order. Is application for extension of interim order.
Yes. You have served a copy.
No, we didn't, I have served the copy at the instance of the Honorable Justice at that time, relevant.
No, but this application you have to serve.
This application I filed, I mentioned before the court, before changing of code from 19 to 5 to this code. I mentioned improperly.
No.
Not availability of.
Appreciate that, but you have to serve this copy because it was till November.
November.
So you have to serve a copy of this application.
In the meantime,
No.
in the meantime, some.
It appears all right.
That 14 Miller. I think 14, I am paying for the opposite party, my lord. No copy of the application has been served upon me, my lord, for extension of interim.
Why have you not served this copy of the application?
I have served.
He is saying you have not served.
Copy, my revision application I have received, but the application for extension of
Extension.
that is also have served upon the parties because he was not available. Means
Have you notified him that you are appearing?
No, Miller.
He has served upon the party. Your client has
There might be, my lord, miscommunication.
entered appearance. You should have intimated the learned advocate for the petitioner. Then he would have served upon you.
Millard,
When was the interim order?
page 9 of the extension application, Millard, the interim order expired in October 2024. Paying for extension, Millard.
What is the impugned order?
My lord, the impugned order, my lord, is of, my lord, closing out, my lord, my plaintiff's evidence. My lord, I am the plaintiff, my lord. A commissioner was appointed in the matter to conduct evidence, my lord. Now, my lord, the petitioner, my lord, is an 82 years old senior citizen. My lord, at the day, my lord, 34 questions were put to him. My lord, after that, he failed.
Right.
My lord, I'm sorry, this matter, my lord, I am not possibly CO 835, I am not happy. My lord, CO
are not happy.
CO
All right. If you need a service filed in court.
I am for the petitioner, my lord. This is a commercial suit, my lord. I filed an application under section 15 for transferring the civil code to the commercial code, and that was rejected.
So now it's extension of interim order. So
my lord, matter is very short point. This is admitted fact. It is heard several times. This is admitted fact. This is commercial suit. Bank was the
They are paying for transfer of the civil suit from the civil code to the commercial code. The suit is of 2014. Now the prosecution witness has been completed.
No, but what is the provision?
15.
The suits cannot be transferred.
No, it can be transferred. I admit that. But if it is transferred from the stage where
has to be. Where is the provision for transfer? Do you have that?
Yes. Section 15, my lord.
15.
It shall have to be transferred to commercial, this prayer was rejected.
Yes,
On what ground?
there is no ground, my lord. According to judge, this is not commercial suit. Just impugn order, my lord. Last, as the said agreement in question is not a commercial dispute. The said petition as filed
That
by.
you are not disputing.
My lord, may I say, my lord, it was a lease agreement between the parties. Now,
Are you disputing that it is a commercial dispute?
my lord, it is a commercial, it emanates from a commercial agreement, my lord. That I cannot deny, my lord.
Should have said that before the learned trial judge, then it would have transferred. It's after all your suit.
Yes, my lord, that.
Uh,
Let the decree holder in an eviction suit is the petitioner before your lordship. Let this suit for eviction initiated not on the ground of default reasonable requirement, building, rebuilding. Ultimately, the suit decree. But if your lordship takes up the plaint, page 18 is the scheduled property, my lord.
Page 18.
So
What is the impugned order, Mr.
by
Mukherjee?
virtue of the impugned order, the learned trial, the appellate court, state the operation of the decree, subject to the condition that 30,000 to be deposited.
What is the wrong in the?
But I am coming, my lord. I know, my lord, this should not be oppressive. This should not be oppressive. But my lord, kindly consider, my lord, they are occupying an area of about 3,000 and odd square feet. My lord, in the ground floor, at the area of
the decree holder. Oh, you want enhancement?
Enhancement. My lord, kindly consider this is my lord, the chartered valuers report. My lord, I prayed, my lord, whatever.
Mr. Mukherjee, what is the appeal is pending?
Appeal is pending.
I'm expediting that.
My lord, kindly, my lord, once looks at this, my lord, it's my right. My lord, it's not that, my lord, I know. My lord, the court, while granting this, my lord, should take a balance. Kindly see, my lord, the chartered valuers.
Did you file this report before then?
My lord, I am coming, my lord. I am coming. To that effect also I am coming, my lord. Kindly consider that I have prayed in my opposition to the stay application. I prayed that the 6,000 should be, my lord, per square feet at that New Alipur area. The court has come down to
6,000 is the monthly rate of rent.
600. 600.
6,000.
600 per square feet. But ultimately, my lord, while my lord, the revisional application is preferred, my lord, my lord, suggested that a chartered valuers report should be a guideline or yardstick because the court has to assist with something. Court cannot take, my lord, something which is not there. So neither party, it is being assisted before the court below. I must submit before your lordship candidly. Nothing was being produced, but I asserted something 600. But the learned judge found that 30,000 should be reasonable. Now, my lord,
So Mukherjee, there is a recording. However, there is no material available before.
I know, my lord.
So you did not file that. What can be done?
My lord, kindly consider one thing. My lord, it is the yardstick. Both the parties should have been assisted. It is the duty of the party who is asking for stay.
Mr. Mukherjee, I will give you leave. You take an appropriate steps before the learned trial.
Kindly do that, my lord. Kindly do that before the learned appellate court. Considering this, my lord, kindly give me that.
You file an application? No, I will not say with that. File an application, make a prayer that will be considered. If you have not produced there, coming up in the revision,
I must
produce something from your pocket and
that cannot be done. That's why, my lord.
So
at the very beginning, I
so
said,
you know what step has to be taken.
I will do that. I will. That also. My lord, I don't have any difficulty
Since you
regarding
have,
this.
since
Yes,
you have moved this
otherwise, my
application,
lord, otherwise affirming this order will have some bearing, my lord, in recalling or praying for modification
then
of
you
that.
should have prayed for withdrawing with liberty. You know the procedure, what is to be done.
Lord, that's why, my lord,
That you have not prayed,
I
Mr.
under the
Mukherjee.
impression that your lordship will gives me that liberty so that I can approach before the court below.
Yes,
Since a new material I wants to rely upon before your lordship.
That review, so review, you have to
No, I am
then,
not also on review because there is no apparent mistake, my lord. The court was not being properly assisted. That's why, my lord. I'm
review cannot be done on any other ground,
not
Mr.
discovery
Mukherjee.
of new document. It is something. It's not
All right.
kindly.
Lordship, my lord, 17 and 18 are analogous matters.
Yes.
But I will be candid to your lordship. I was on caveat, but due to a medical exigency, I could only serve the hard copy yesterday. I've also served by way of email, but that also only I could serve the hard copy and the soft copy only yesterday. So I'm not standing in the way, my lord, if your lordship wants to just adjourn it for a week. This is simply, my lord, regarding amendment of pleadings. I am a developer. The opposite party is the defendant where I have filed the suit. He has not paid maintenance charges. And I wanted to amend the suit because there was some calculation error. It is nobody's case, my lord, that I am changing the nature and character of the suit.
Has the trial started?
My lord, only the affidavit in chief has been filed. There has been no examination in chief. That is exactly why, my lord, now it is on the verge of trial being started. Lord, only the calculation, and the defendant had said that I have not revealed what calculation, on what calculation I am charging.
The learned advocate appearing for the petitioner submits that
My lord, I am for the petitioner, my lord. My lord, expeditious disposal, my lord, of one application under 151, my lord, seeking police help. That has been, my lord, filed on 18th of April 2024. And my lord, the police was directed to submit a report. That
18th of April,
2020. Lordship, can you take up page 27?
page 27. Yes.
On this date, my lord.
What is the next date?
My lord, 127, my lord. 27, page 27 is the order dated 18th of April 2024.
Yes.
My lord,
Because injunction application and for report.
My lord, initially, my lord, plenty files.
Injunction application is pending or disposed of.
Pending. My lord, I have secured and
I'm directing the injunction application to be disposed of.
151 is pending still.
Maybe.
My lord, kindly consider, my lord, 18th of April, my lord, 151 was filed. My lord, police was directed to submit a report.
So prior to that, the injunction was filed.
Prior to that, the injunction was filed, my lord.
So I'm directing the injunction to be disposed of.
My lord, as well as this application itself.
First injunction,
My
thereafter
lord, the
that.
police has also, my lord, submitted a report, my lord. Kindly consider.
Maybe.
But
Let the injunction be disposed of first.
that is also pending. The report is also pending, my lord, since 1 year.
Written objection has been filed.
Written objection, my lord, has been, there is no, my lord, recording with subject to, my lord, the injunction. Since, my lord, order 39, rule 7 was filed, that was
20, my lord, I am
Yes.
the heirs of the deceased who is the defendant in the suit, filed an application for addition of party, where the same was turned down on the ground that during pendency of the suit, the estate of the deceased has been transferred. So that's why the heirs of the defendant is not there.
Why are you disputing that?
There is some dispute to that aspect, my lord.
Not transferred.
Transferred to what extent transferred? That is Order 22 Rule 10. Manor Kali consider Order 22 Rule 10. It is rest about the.
Mr. Rai, I appreciate that. But if the fact remains, Order 22, Rule 10.
It is for the.
Yes. So if the subsequent purchaser do not get himself impleaded, even if it does not get himself impleaded, he will be bound by the result of the suit. So he will be in addition. Now, if your estate is now being represented by the subsequent,
that is
what is the use of
there is
further
in the passage.
substituting you?
That
Because he will not be interested in further proceeding with the suit.
That is why, well, there is passage. Why my application under order Rule 10? There is a passage, dispute is the passage. 3 buildings are there. So for the property in question, that has been transferred. But the easement right over the passage is still is disputed question. Whether, my lord?
No, but you are retaining any portion of the property, then
retaining my own portion, but the dispute here is the easement right of the passage, which is a common passage.
But Mr. Rai, you have transferred that property.
Not the passage. That is the
Mr. Rai, the easementary right
attached with the suit.
Attached with that property. So if you have transferred the dominant heritage, do you have a right of easementary right over that?
Now, my lord, consider whether the property in question, I have the right.
These facts are there. The original dominant heritage has been transferred. Do you still retain your easementary right over that common passage?
Whether if my other estate is there through whom that is what precisely that is why I can turn to my application. Page 31. What is the necessity for filing of this application?
Yes. So you are retaining any portion.
So suit property I have not retaining portion. But this passage continues.
Mr. Rai, you are the defendant or you are the heirs of the defendant.
I am the heir, sir. My lord, I am the heir, sir.
Show me the suit property.
Yes. I turn to page 10.
Page 10.
Yes.
Yes.
Now, my lord, can you turn to my written statement?
No, there, what is the claim of the plaintiff? Claim of the plaintiff is declaration over the suit
right.
property of exclusive right. Over
Now,
a scheduled property.
Yes.
Over the suit property. Suit property has not been described A or B.
Page 14.
Oh, A. This is the sketch map.
Yes.
Now, part and parcel of A schedule property, the common passage this is the common passage in the eastern portion of A schedule. Now, the plaintiff claims to be the owner of both A and B.
Yes. Exclusive ownership. Can you turn to B? Page 16.
This is the written statement.
Yes. Along with counterclaim.
Is by your predecessor.
Yes.
Yes.
Now I can turn to page 19.
Page 19, yes.
I'm skipping over the same. Mother, can you consider what is the prayer made? Can you turn to page 27?
Page 27, yes.
Last portion.
Declaring that the 6 feet wide common passage which has been mentioned in Schedule B is exclusively common passage among the original owner and the purchaser and their heirs and aside further the plaintiff has got no right. Yes, over the common passage.
Yes.
So according to you, this is the common passage for whom? The owners of the property.
Oh, but now
you have sold that portion.
Whether right to sue transferred. This is my counterclaim. This is my counterclaim.
Yes.
Then, my lord, if Manor Kali considers
Mr. Rai, are you getting yourself substituted in the counterclaim or in the suit? Because you are saying as a defendant number 2.
That is why Manor Kali turn to page 31.
Is a separate suit. Where is your application for being substituted?
Page 31.
Mr. Rai, that has abated. If you have not taken steps, that has abated.
That is
counterclaim has abated.
Not one of the years are already on record, but that is page 31.
One of the years of the defendant number 2 is already on record.
that is there. Before that, my lord, can turn to page 31.
Yes. Yes.
Your lordship can turn to paragraph 3.
Yes. So it's, you are trying to get yourself implemented in the suit, not in the counterclaim. So two separate proceedings, Mr. Rai. You want to rely upon your claim in the counterclaim, then you have to get yourself implemented in the counterclaim also. Statement says plaintiff has not implemented you, meaning thereby in his suit, not in your counterclaim. Counterclaim has already abated.
Counterclaim, my lord. So
Separate proceedings, Mr. Rai. All proceedings will, if you do not get yourself substituted,
so the
abated.
goes.
Counterclaim goes. If the
Now, my
counterclaim
lord,
goes,
suit. My lord, can you call the suit?
yes, now Mr. Rai, now counterclaim, your claim for that goes.
I can defend the same. In the
Now
plate.
you can defend the same. Now the question is, if the portion of your property by virtue of which you are using that common passage, if you have transferred, do you still retain any right over that common passage? This is for the purpose of users, of the purchasers. You do not have any right since you have transferred. Common is for whom? This application under Article 227 of the Constitution.
Your lordship, I'm for praying for time for petitioner, your lordship. Lordship, the counsel is not well, your lordship, appearing.
This is an application for expeditious hearing, madam.
Your lordship.
You want time?
Yes, your lordship.
On the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned. Hearing of the civil division application stands adjourned. Next.
I beg to appear. I beg to appear, my lord. In a suit for partition, my lord, the plaintiff is the petitioner. Injunction order was passed, my lord, to the extent maintaining nature status quo with respect to nature, character, and possession. Thereafter, my lord, by the impugned order, it has been extended. But by the impugned order itself, my lord, on the basis of an application under section 151 filed by the defendant, allowed the construction to be raised as it was sanctioned under the government project.
You are the plaintiff.
I am the plaintiff.
You also have a house in that property.
No.
You do not have, you
No.
do not want to construct any house.
No, no, it is not. We have the 2/3 share. They have their house. They have their house. Adjoining to that house.
What is your objection?
Their, my lord,
Then ego problem.
more,
What is
more,
your-
more extent, more extent. They have
you stated so.
Yes, yes. My lord, kindly, in my objection, my lord, kindly have a look to my objection.
Yes.
Page
Where is their application? Show me first.
application to my lord, kindly allow me to hand over, my lord. It was not available.
What is not available?
That application at the time of filing.
But you have annexed your written objection. You have not annexed his application.
It was not. Yes.
What is the food property? What is the measurement of the food property?
Measurement is, my lord, we have 2/3, they have 1/3.
They have 1/3. What is
1/3,
the
3 decimal, only 3 decimal they have. Already, my lord.
So that you are not disputing.
No. My lord,
So I will restrict them. They will construct only in respect of.
my lord, the difficulty is, my lord, the trial court held, my lord, my lord, kindly come to impugned order once. By the impugned order, it was allowed, the injunction was allowed.
Yes, yes, yes.
And by an application, since it is government fund, it is, my lord, may I
They also have a share in the property. 1/3 share, 3 decimals they have.
They have already construction. Already they have the construction, their house is there. In their application, they say, my lord, adjoining to my old house, I am constructing. But so it is beyond their
I will
scope.
make it clear, it will cannot exceed 3 decimals.
My lord, already they are exceeding. My lord, the difficulty would be.
Where have you stated
Yes,
that in
yes,
the written
already.
objection?
My lord, kindly come to my page 46, my lord, para 4.
Page 46. What is page 46?
My-
Page 48 is your objection. Show me from your written objection.
Yes, the written objection is page 46. My lord, annexure. Key leakages. Yes, it is para 4 in my written objection. stay of the impugned order to the extent allowed by the impugned order injunction also allowed to be continued.
Stay of the operation of the impugned order.
My lord, after filing the application, we discovered that there are certain mistakes in the application and we failed to annex the recalling application we made before the second bench. Otherwise, the case is ready to be heard.
Yes.
So I am the defendant number 1 in an eviction suit. You haven't been served, so it's between the court and me. Okay,
No, I have
you
not
can
been.
say after me. Okay?
I
am the
have been
defendant. my lord.
instructed to appear for the opposite party. There is no caveat on my part. Now, if they give us a copy, then we can respond. Otherwise, we will not be able to respond.
No, we will serve you later on. So, my lord, I am defendant number 1. I'm the main defendant in this case. And without giving me a chance to adduce my evidence, the suit has allowed the plaintiff only to give evidence. And this is an eviction suit against me. I own this property. I live in this property. And this was a mortgage property at one time. My only issue is why the plaintiff should be allowed to give evidence when I won't be. I only want to adduce my evidence. That's it. And that application is pending.
Which application is pending?
The application which we made to adduce evidence before the second bench. And the learned judge kept it for argument without.
To recall 9th of December.
Yes, that would be.
So
at the end.
What is the date fixed for hearing of this?
It's today.
Today?
Yeah.
Yes, Mr. Dotto. They have filed an application for recalling.
I have to take instruction. I don't know anything, my lord.
My lord,
on what basis they have filed a civil revision?
It's clear. I want to adduce the evidence.
My lord, it came to across me, my lord, when I saw the list, my lord. I immediately came before the court. I indicated at the very first instance, give me a copy. I will take instruction. I will be able to properly assist the court. Otherwise, I have only the case status.
Do you have any difficulty in giving him a copy?
Not.
Are you trying to hide anything?
Not at all.
Please give a copy to him.
We will serve a copy.
Please serve. Please serve.
At the moment, we don't have a copy, but we will serve today.
Yes, please serve.
In 2 hours, we'll serve a copy. Within 2 hours, we'll serve a copy.
I will take it up on Tuesday. Please serve. When this matter is taken up for. Yes.
My lord, the husband is the petitioner here, lordship. Lordship, the husband filed an application for divorce before the additional district judge Barashat.
What is the impugned order?
Impugned order is the last stage, lordship.
This is what has been done by the impugned order.
Yes, lordship. Alimony has been granted to the wife, lordship, of 20,000 for 2 years old baby and 5,000 for herself. Challenging that order, lordship, this petitioner came before this honorable court, lordship. Lordship, both parties filed the affidavit of assets, lordship, and the wife has a income.
What are you doing?
I have a business, lordship.
What is the finding of the learned trial judge with regard to your income?
Lordship, they have basing upon the affidavit of assets of both parties lordship and stated that lordship as it is the responsibility of the, it is on the inner page 3.
Wife is earning.
Earning as per her salary slip lordship 20,000, 18,000, 20,000, it varies lordship. I have annexed those documents also. Lordship, page 67, Lordship. She is working in Bhumi fashion. She is a fashion designer. And it would be evident that 20,300, 800 perhaps, Lordship. As salary. And she is staying in my house, Lordship, and my father is paying all her expenditure.
Where is the finding with regard to the income of the wife?
Finding.
Yes, court's finding with regard to the income of the wife.
The para 3, middle of the page, Lordship.
Para 3.
Page 3, Lordship, inner page 3 of the.
Yes. Inner page 3, which paragraph?
Middle of the page, Lordship, the learned advocate for the.
This is a submission. I want to know the finding of the court.
It is the para 4, page 4, Lordship.
Yes.
Not the separately, but it is all along it has been decided in this page, Lordship. It has been independent income of the wife petitioner as narrated in the affidavit of asset is relevant consideration.
Yes. None appears for the petitioner at the time of call. No. Same order. Next.
7.
Yes.
27, my lord, I am appearing for the petition. There are two revisional applications. One is appearing item number 27, another is appearing item number 51. Your lordship, ma'am.
51.
62, 62.
62, sorry.
The same cause of action, yes, 62. Because 8 years before, one order was passed and challenging that order, he has come, 1599, 62. Kindly lordship, it should be
Item
heard.
number 62 tar part korun to.
Serial to 62.
Yes, Mr. Rai. What is this matter?
62.
The defense
62 is the earlier order.
earlier.
So unless you succeed in that, nothing remains in this.
Subject to question, my lord, there are two standing on two different footings. One is, my lord, whether the order, wherever the earlier the fingerprint expert has been allowed, whether that can be allowed or not, in view of the admission made by the plaintiff in her deposition.
So I could not follow. Earlier, there was an appointment of a handwriting expert.
That is subject matter of challenge in the earlier revision application, which is appearing at item number 62. And the subsequent one, I filed an application for re-examination of the handwriting expert. That was turned down.
Re-examination?
Because I have examined but certain points are left out, so I prayed for re-examination.
So, Mr. Rai, at this point of time, can the earlier order of appointment...
Yes, well, subject to question, if you logically consider, if a document was tendered to the witness, who is the plaintiff herself.
What is the date of the earlier order?
2018, subject to question.
So, after these long years, why you will be permitted to challenge this now?
I mentioned in the
13 November 2006.
Ground for the delay.
Yes.
Sir. Yes, Mr. Rai, where is the ground for delay? Where is your explanation?
Paragraph 9, 10. These are the two grounds.
This cannot be a ground. Earlier, you were not allowed. Thereafter, you have taken these steps. You have filed this application for re-examination. You have participated in that proceedings.
Precisely, what is there about 9 and 10? These are the grounds. Apart from now, one can turn to the plaintiff itself.
So you want to move item number 61 first?
First 61. Because if
62,
61 or 62? Yes, 62. Yes.
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 Huh?
This is CO 1599 of 2025. Yes.
Yes.
Yes. Plaint is annexed in which?
Plaint, page 10.
Of which matter?
1599. My lord is looking 1599.
Mr. Rai, whether you have annexed all papers in 1600?
Yes.
The earlier order is also there. So can we look
Yes,
at
yes,
1600? Yes.
Plaint you'll also find at page 11.
Yes. Yes.
Allegation is that some documents were been obtained by the defendant for the purpose of creation of partnership deed. And for that, my lord, a declaration was sought for that, my lord, the prayer precisely, you'll also find at page 16.
You are the plaintiff.
I'm the defendant.
You are, oh, he's the plaintiff.
I am the plaintiff.
Now, what are the documents?
Yes. Document is one letter. Now, my lord, can you consider?
So, enforcing the signed blank papers and documents signed by the plaintiff lying with the defendant.
Yes. Now, it is her case that it has some documents are obtained by defendant on blank paper, some that cannot be retained by the defendant on the pretext that the defendant used to look after the partnership business, but taking
Right.
advantage of that.
So, who filed an application for?
Yes.
Uh,
Before that, your lordship can turn to page 26, the deposition of PW1.
Yes.
I am drawing lordship attention to page 36.
36, yes.
62. Question number 62.
Yes.
But the signature, my lord, I have
What is your name?
Nipoti.
Nipoti is your name. Yes.
But the signature put on the letter addressed to Nipoti Babu probably dated 22nd.
Is of mine.
Is of mine.
This is whose evidence?
This is PW1 plaintiff's.
His evidence.
Oh, yes.
So he admits that it is his signature.
Her signature. Now, my lord, can you turn to
Sorry. Yes.
page 39. The application filed for handwriting expert.
Yes.
There is matter to be examined, page 40.
She is Jharna Das.
Yes. The expert is to examine the alleged signature of Jharna Das allegedly appearing in the alleged retirement letter dated 22nd December 2000.
When this application was filed?
After it was filed, after adducing of evidence, subject to caution.
What is the date?
Date, my lord. 13/6/2011.
Where do you find that date?
Page 46.
Page 46 is the order.
Order there, my lord.
Order that has been said. So what is the date? Please tell me the date.
13/6/2011.
13/6/2011.
And the cross-examination in respect of that question was put on 15/5/2007.
Yes, where is the and another point? There were 2 points.
Another point is the expert to examine the alleged signature Jharna Das appearing in the alleged balance sheet for the year such and such, mark C1 with the admitted signature of Jharna Das bearing in the deed of partnership dated such and such.
So 2 things. One is in that retirement letter
and the balance sheet.
Another is the balance sheet.
Yes.
Yes. Now what is the order?
What
has been annexed here?
Yes, page 46. That is precise.
Yes.
I am drawing lordship attention so far.
This challenged in CO.
Earlier CO.
CO 1599.
Yes.
Yes.
Can you turn to page 47? I've got it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines from the top. Right hand corner, right hand side in the deposition dated 15/5/2007.
Yes.
The plaintiff admitted the signature of hers, but there is no averment regarding the contents of the letter dated such and such. At this stage, it is not prudent to appreciate evidential value and effect of documentary evidence after considering all the aspects appearing before this court. I find there has been long-standing dispute. Partners of the partnership firm. This suit is for declaration of permanent injunction. There is sought for relief of injunction against the defendant, restraining him to use the paper signed by the plaintiff and also restraining the defendant from disturbing the plaintiff running of the partnership business of Sharad I's factory. Hence, genuineness of the letter of retirement is crucial factor for final determination of the suit. Pause there for a moment. So, what does the constitution and what does the prayer mean?
Give me a minute.
আমি বসে বলবো
Yes, Mr. Rai. Page 47 you are placing.
Yes.
Yes.
So what is the premises for the purpose of allowing this application for the genuineness of that letter?
Contents.
Contents, whether there is any prayer for examination, signature prayed for, admitted. Whether the contents can be proved by the, whether it can be proved by a handwriting expert which has not been prayed for also. So what will prevail? The person who is facing the doc admitted her signature, saying that yes, signature is mine. Whether for the purpose of ascertaining the genuineness of signature, whether this handwriting, this application can be allowed or not. That is the one aspect of the matter. Whether if it is a term to a piece of evidence, so the direct evidence on the part of the person who has put a signature can be contradicted by a expert evidence. This is a mere piece of evidence will be considered along with the other evidence. So whether this is permissible or not. Next, my lord knows better than us, my lord. So order 22 the opportunity was granted to me for cross-examination of the, because we filed objection to the report.
So this is all along with regard to 1599.
This is all 1599.
Now you are on the next matter.
Next matter.
Only one thing. Explanation for the delay.
That is, but can you consider if a order which is glaring on the face, and I have explained, it is not that day-to-day expression, it is falsifiable expression or not, subjective satisfaction or not. And 227 whether it is absolute bar.
Anything?
Citation.
Of time 227, whatever for what.
Subject to satisfaction of the court. Well, I have give expression which is the subject matter decision of the court to accept it or not. Whether this sort of order to be written in the record for the purpose of genuineness of a document which has not been even prayed for.
Yes. And other matter?
Other matter is that, yes.
What now the report is there.
Report says.
You have examined him.
Yes, I have examined him. I have missed.
So you wanted recall of that.
To put some other questions.
Where are those other questions?
Page 67 your lordship will find. Last 3 lines on these 1, 2, 3, 4, 5, 6, 7 lines from the bottom, page 69. On the premises of this, my lord, report, I want to put some other questions. Not other questions. Not
what other questions, Mr. Rai, you have to
that an expert in furtherance apparently which are looking alike, biased in nature.
Which paragraph?
Paragraph 5.
Yes.
Page 69. May I read out? Hence, after going through all of the defendants intended to re-examine the said report in presence of the concerned handwriting expert by our active
questions you have not put. What questions?
No. The premises on which I will put the question, that
but
is
you have to specify the questions.
I could have understood the court is of the opinion in absence of any question precisely on that question. I am rejecting your application.
That is not there. This court can supply. This court can supply the reasons, Mr. Rai.
Then, I am entitled to get an opportunity to put the question on technical ground. If it is rejected, then I can rectify by technical ground.
Got to have made a
within reasons.
And can turn to the order
that is not there, Mr. Rai.
In the order, I could understand on technical ground if it is rejected.
Not technical, Mr. Rai, because it's not
on the premises.
Say it's technical, but it is re-examination with some purpose. Again, you will recall. You will say, "I will put 100 questions to you." So what
that is also the premises. On the premises,
can look into those questions whether that is relevant or not relevant. Then the court can permit you to re-examine. It's not at your own wish that you will re-examine.
It is why paragraph 5. But I have mentioned that what
paragraph 5 is very vague to put certain questions to unearth.
No, why it has said that it is not simulated. That is what. In process of unearth some undiscussed truth, the previous examiner chief handed explained further apparently which are looking alike by part to the open from her and obviously not in consonance with the said order.
To unearth some undiscovered truth.
Because it was only for the purpose of handwriting. The content
investigation, unearth the truth. By an investigating agency, Mr. Rai.
I am not investigating.
That is your statement in this application unearth the truth.
My lord, my lord is going through the drafting as
No, not the drafting. You have said this is the reason surface
what the reasons?
in the paragraph, not in the form of the questions. That is why
No, it is there. It is there. It is not that totally assessed.
what the court has held.
Yes. That heard the submission of both the sides, my lord got it.
Yes.
First thing is a strong objection against the submission of the defendant on the ground that AIC.
On the ground that? What is AIC?
AIC does not. Application, probably, my lord.
Application.
Does not bear the signature of the deponent. Furthermore, AIC has been filed without any affidavit. And constitution elaborately at
AIC.
Application for re-examination that may consider AIC.
No, I think affidavit in chief.
No, affidavit is here. Plaintiff is defendant submits with the court that filed one AIC.
The application for re-examination of application for
What is AIC?
Yes.
AIC. I also
Yes, filed one AIC for re-examination of the handwriting expert. So AIC presupposes one of that application.
Because he wants to re-examine the expert.
Yes, yes. Yes, next.
So these are the technical points which has been. So what are the points which have mentioned, my lord? Plaintiff raised strong objection.
The reasoning is right. Says that the has unable to satisfy the court the fact why he wants to re-examine the handwriting expert. That is the sum and substance of this order. That purpose has to be what, why, because you have extensive. It's not a case that you have not examined him, or if you could not did not have or for some reasons.
That is something.
So there is nothing wrong in this impugned order, Mr. Rai.
So far, if you logically consider, so
in this order.
So the earlier one, that is why the earlier one. Whether the contents can be proved.
Yes.
By handwriting expert. And whether delay can be a sole ground for defeating. It can be compensated by cost also. It can be compensated. But
and you have participated so long.
Participation, whether it
filed for re-examination,
that
so
is,
shall it not be deemed that you have accepted all those?
Deeming and participation in the proceedings is standing on two different footings. You will logically consider. I have a right to challenge the same. I have a delay. I have allowed to continue. But that design
can it not be said in that way that that order now you are challenging? Let us keep it aside. With these facts, can it not be said that that order had already attained finality?
Finality, if it is
now you are challenging. Now the question is, so when the parties proceeded with the later subsequent stages of the proceedings on one basis, so whether the doctrine of res judicata will not apply, and whether because it applies in the subsequent, now at some stage, so you are coming, taking advantage of the fact that there is no prescribed period of limitation under Article 227. That is the only ground for which you are coming after 9 years.
8 years.
8 years and 9 years, Mr. I is the same thing, challenging the order. Nothing more. Only 365 days less it would be.
So,
delay will be only 365 days less.
Degree passed. Subsequently, final degree was been also passed. Whether somebody is entitled to challenge the plenary degree, Kali considering that way also. Kali considering that way. That my lord is then somebody participating in the final degree proceedings is entitled to challenge the plenary degree.
But if you only challenge the final degree, you cannot reopen, Mr. Raj, the preliminary degree.
I cannot reopen preliminary degree.
So you have to challenge that.
Yes.
But it's not.
That is why in different stages on same suit.
No, but that is a decree also. Mr. Rai, you cannot equate that with this. Because preliminary decree is also a decree. Final decree is also a decree.
This is the order.
That is why if you do not challenge, you have to challenge it separately. Unless you challenge, you only challenge the final decree. You are barred from challenging the preliminary decree.
Precisely,
so those are so don't equate that with this.
If that not be so, my lord, here, my lord, I have
your ground whether for rejecting your prayer for challenging this.
My lord, kindly consider, if that be so,
Because the parties proceeded on
still
one
proceeded, whether,
took steps. Yourself, you took further steps, as well as in the order which is under challenge.
that is precisely,
Same point of time you are challenging both these orders.
that is why, my lord, precisely, my lord, this is my argument, whether I have participated in the final degree proceedings. Two stages in a same suit. Suit is one, two stages. Here, my lord, I know that if I challenge the said order, it does not, because the constitutional executive will apply in the same proceedings. So this order is staring in my on my face. If I challenge this order, if I did not challenge the appointment itself. My lord is of the opinion, if I participate in the further proceedings, this amounts to adjudicated regarding my entitlement
Because
to
you proceeded
on the-
accepting
that is
accepting that order.
that is precisely, my lord.
That order has been accepted, and you
Yes.
have proceeded with the suit, taken steps thereafter. Now can you
That is why precisely, my lord,
reverse the entire
whether my lord can consider final degree, that is why precisely, my lord, I am arguing whether final degree passed. At the time of challenging the final degree, I found that there is degree required to be challenged. Some other, whether I am disentitled or it will be adjudicator. Then, my lord, if your lordship that judgment, my lord, Justice Mondol has passed this order. Once executor satisfied, order and rule that will not apply. The same principle will apply also here. Execution is satisfied, so no order and rule 13.
Mr. Rai, I think in the last week I have passed an order on that.
So, if you
Passed an order on that, giving my reasons.
that is something else.
Considered in that judgment.
That is something else.
Keeping in mind that judgment, I have delivered giving reasons as to why this can be also
not maintainable.
No. Order 9 Rule 13 is maintainable even after execution. So, reasons I have assigned, keeping in mind that judgment, though that judgment was not placed before. But keeping in mind that I have
So this is what premises of my argument. Whether the passing of subsequent order can disentitle me to challenge the earlier order.
Mr. Rai, kindly come to explanation to section 2, subsection 2.
Section
This
2
is the answer to your
Section
submission.
2, subsection 1.
Now, section 2, subsection 2, degree definition,
Yes.
explanation. That is the reason.
Yes.
So, but it does not apply here. There, why you can be permitted to challenge? Because it does not, suit is not completely disposed of. That is a question of decree, unless because further proceedings are required to be taken. Because what is the ultimate object of a partition suit? It's not merely declaration of shares. So it's severance of
interest,
title and possession. So that does not get severed till the final decree is passed. Preliminary decree is only one stage.
Yes.
In the suit, only declaring the shares. So that is why the suit ultimately gets decreed in the final decree. Then you can only challenge the final decree, and you can also challenge the preliminary decree, because there will be no limitation. If after passing of the final decree, you challenge the preliminary decree, it will not be barred by limitation. This is only because of this explanation.
That is a minor concern, or section 2, subsection 2, along with 97.
97, yes. 97 says if you do not challenge the preliminary decree, then that will be barred. In an appeal arising out of a final decree, unless you challenge that, you are barred from challenging, questioning the correctness of the preliminary decree.
That is precisely what that is why.
That is a different thing altogether. Because, Mr. Rai, the limitation for challenging the preliminary decree will not start running from there. You can very well challenge when the suit is ultimately
subject to preliminary decree, on the date, on the passing of the preliminary decree regarding the declaration of the shares of the party.
Can challenge. But if Let us suppose final decree is passed. In that you are challenging both.
In that one, yes, that
So it will cannot be said it's barred because
this is barred by limitation. That will be barred by limitation.
Yes.
So, but the entitlement stands.
What will be barred by limitation?
That the preliminary degree it just passed because the date running from the date of passing of the preliminary degree. Can you consider?
Section 97 once.
Appeal prescribes on Limitation Act.
Yes.
So
if you do not challenge the preliminary decree,
I
you cannot question that. But if you challenge the preliminary decree along with the final decree, then you can only question that.
Question that pursuant to that.
That is the declaration of the shares only.
The limitation will start from the passing of the preliminary degree.
Yes, yes. That is with regard to the declaration of shares part.
Yes.
That is with regard to the declaration of shares part. Now, in the appeal, after the final decree, unless you have challenged, you cannot question the preliminary decree.
Yes, I cannot.
So that stage, Mr. Rai attains finality unless it's challenged.
Here, my lord, in there, my lord is going to the constructive residuator or residuator on the ground.
So far as that appointment part is concerned.
The appointment part, because my lord, can you consider?
Because Mr. Rai, this is the catch. There, unless you challenge within that period, limitation.
Here,
now let us suppose there was no limitation for that.
Yes.
Then you can say, yes, after the final degree, I will challenge the preliminary degree. So, if it was no limitation was there, that could have been. You are trying to take
here, one of the before passing of the judgment, I have challenged.
All right, let me hear him.
And my lord, so if that be so, my lord, then my lord, any interlocutory order, if I subsequently participate in the proceeding, does it disentitle me to challenge the said order? Even if I participate, my lord, can you consider that extent also?
Mr. Rai, there are different types of interlocutory orders.
Yes.
Some interlocutory orders have a final effect with the suit, have a bearing with the suit. Here is an appointment made. The question would be with regard to the appointment, thereafter you have taken steps for examining him as per Order 26, Rule 10, Sub Rule 2, because you have a right to cross-examine.
That is there, but I have not considered that portion.
Now is the question whether you can re-examine, that is another part.
That is that's why at the very beginning I stated that standing on two different footings.
It's only on the ground of delay, Mr. Rai.
Delay, that is why it can be
something has
whether
taken place in the meantime.
My lord has to consider whether subsequent participants in the proceedings.
More, Mr. Rai.
No, and the delay can be compensated.
Delay you can compensate. It's very easy, Mr. Rai, to say so.
Lordships, you got the point. So nothing is, Lordships, to add. Only, Lordships, I like to add.
You don't have to add anything.
Lordships.
Don't rely on these observations. That was only to counter Mr. Rai.
Lordships, I only because
make your submissions.
Because I
rely upon the observations.
Lordships, I am compelled to say that my learned friend's client is habitual froster. Lordships on the
How do you support this order?
Lordships,
please address on the merits of this order.
I am coming at first, then Lordships. Because the habitual froster, Lordships, he was convicted. Lordships, the 2 years
that is neither here nor there. We are not deciding that
cases. For the forgery
maybe.
So number of forgery losses.
Maybe that cannot be a ground.
The forgery losses in his blood.
That was also not the subject matter of consideration by the learned trial judge while passing the
after the 24 years, the suit is filed at 2021, Lordships. And now is the 25. After 25 years, Lordships, he now, Lordships want to re-examine the
no, that is the subsequent part. That is the subsequent part.
First part is concerned 18
address on the order dated.
There is no explanation. The delay explanation. There is no sufficient delay explanation.
On merits.
On
merits.
And on merits.
That is on delay. On merits.
And merits, my lords. Because
yes.
Lordships, you know, the Lordships, the 39 and 41 probably, the BSA of 2023 was the lordships of corresponding law, lordships of section 45 and 47. The court has formed an opinions, lordships, the handwriting expert, handwriting who has been appointed.
Will give an opinion as to what?
As to what the handwriting, lordships, it is because
Show me there is a dispute with regard to the handwriting. Show me that. Show me there is a dispute with regard to
nothing,
handwriting.
because it is the discretion of the court. The court has come to
Even if it is not a dispute,
court has formed an opinion. It is a relevant fact.
even if it is not in
This
dispute,
is a relevant fact.
show me that.
So,
Show me the provision. If it is not in dispute, it has to be referred to.
No,
Show me that.
lordships, you know, lordships, it is not a disputed or lordships, it is a disputed or not. Currently, lordships, see the 39 of the BSA lordships. You see not lordships 30.
নতুন অ্যাক্ট গুলো আছে?
New act lordships, old act lordships, you can leave
Evidence একটা দিন তো section 45.
Huh? Lordships, this is because
Evidence একটা আছে?
আছে ওইটা।
Evidence Act section 45, yes.
The opinion of expert lordships. When the court has to form an opinion upon a point of, not for an expert, because as to the identity of handwriting, the opinion upon the point of person specifically skilled, because it is a CID lordships, question document of CID lordships, the person has been appointed as a skilled person, as an expert, and skill in such foreign law, science and art, or in question of identity of handwriting are relevant facts, and such persons are called experts. Then 40 lordships is 41 probably. Opinion as to handwriting and signature when relevant. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion.
Section 41.
No, not a copy one. Lordship, the opinion of any person acquainted with the handwriting of any person is specifically for the handwriting. But
Yes.
when it is supposed to be written or signed that it was or was not written or signed by that person, it is
Yes.
a relevant fact. Again, a relevant fact. So court has formed an opinion, it is a relevant fact. When? Because after 24 years, Lordship, he has come before the court with an application without affidavit. Lordship, it is not a proper lordship, because after completion of
Which application?
the cross examination to the
Which application was without affidavit? Which application?
that examination for
Examination.
re-examination.
So you have completed your submission with regard to 1599. That is your submission, those two sections. And that there is no explanation for the delay.
There is no explanation for the delay.
And section 41 and 45.
Now I am coming, Lordship, because the second part is concerned.
Second application.
Second
So first application you have completed.
First
Yes,
application.
second application.
First application, any other query, my lord, Lordships, you have?
No. You can make your submissions. He has made his submissions. You can give your reply.
I say, Lordships, after 8 years, Lordships, certainly, Lordships, when he come, certainly explanation, reasonable explanation should be given. Without explanation, what the explanation he has given? Section para 9, Lordships, you kindly already you have seen, Lordships, because there is no explanation. So now, Lordships, I think that after 8 years, Lordships has a power. Lordships may. Lordships thinks that this order should be Lordships allowed. So Lordships may.
The court has that power.
Court Lordships, because you are the High Court, Lordships, you are the every power you have. But Lordships, for whom? Because already the state versus this case, already same case, criminal case that he was convicted for 2 years, and
Sir,
now
please,
he's been an appeal.
please do not say anything which is not in the records of
Not
the
in the
trial
record,
court.
Lordships,
No. In the order. I am
in the order, because he's
So please do not make any submissions
Lordship,
which
the
the
law
trial
gives
court
a
did not
person
take into consideration,
when person has
because I am
come,
only
he-
considering these two interlocutory orders.
My lord,
Please do not make any
My lord,
submissions
a
which are not
person-
part of the.
a person when has come before the court, he should come with a clean hands. Lordships, this person, Lordships, the character you see, if you see 2001, I am the Lordship, he is my brother-in-law. He is my brother-in-law. I am the widowed now. Only because my husband, Lordship.
Can you not settle? Because this is a close relations.
Oh,
Can you not
because,
settle?
Lordship, my brother-in-law now trying to evict me from the house. One revision application again. Only for whom? And I am fighting because I am the widow, Lordship. I have lost my father.
All right.
My
So, what is your submission with regard to the second revision
second
application?
application is concerned, Lordship. No, because
No ground, no questions
no
have been.
ground, no question.
Anything more?
And after completion of cross-examination, complete manner, Lordship again re-examine.
All right.
Why?
Anything more?
Lordship,
Heartbeat.
Lordship,
Cited decisions.
no side, no side.
Need for some protection till
Oh, what is the next date? What is the next date?
17th, subject to correction, my lord. নিচে করে ডেট কবে আছে স্যার?
17th of May.
3-5 ছিল।
3-5 ছিল তার 17 subject to
3-5 ছিল।
17th of May.
this one it is.
All right. There shall be an order of stay of all further proceedings in title suit number 125 of 2012, pending before the Learned Civil Judge, Junior Division, Kagdeep, District 24, Pagana South, till the disposal of these civil division applications. Yes, next.
আমি যেটাকে বলে
আচ্ছা একটা লিখে নিন since কি 12টার সময় ফিক্স ছিল না? Twelve PM matters. Please.
28 and 29. I'm praying not today, Lordship.
28 and 29. Don't pray for not today now. Please wait.
Lordship, and 25 and 26 has been dismissed. All are the same matters, Lordship, because the caveat has not been filed.
If you are not present, what can be done?
Lordship, I was just engaged, and I was running the
25 and 26 was dismissed for default. So,
all 25, 26, 28 and 29.
25, 26 টা dismiss for default যেটা restore করে দিন. You have served upon the caveator.
No,
there is no caveat. ওটা restore করে দিন. Yes. Call the 12 noon matters.
46.
Well, two defendants in a suit for partition, my lord, which was decreed ex parte, my lord. Final decree passed ex parte, my lord. Thereafter, my lord, execution has been levied. My lord, in the execution case, my lord. Partition suit, my lord. Execution case has been levied, my lord. In the execution case, there is a point taken, my lord. 47 point is taken. Two of the defendants have died, my lord. They have not been substituted, my lord. In the
decree is nullity.
No. Execution in the
no, the decree is nullity. The decree was against the dead person.
Decree was not in. Subsequent to the
execution case is
execution case, my lord. The
what is the impugned order, Mr. Sen?
But application for stay in connection with section 47 has been rejected, my lord. But some breathing time may be given, my lord.
You will vacate.
But things will change, but it's not vacating, my lord. It's regarding, my lord, the
yes.
portion of the.
So the portion which you are not entitled to, you have to vacate that, Mr. Sen.
But vacating, man, so as such, not vacating, my lord. It's regarding, my lord, entrance and courtyard, that part, my lord, not the building part.
But
case.
Mr. Sen, stay is not a matter of course, Mr.
But no, my lord, we have specifically stated, my lord, the two substitutions were brought in record were not done, my lord, that the learned trial judge has held, my lord. That is there, my lord. They have not been brought out.
There is no abatement in an execution proceedings, Mr. Sen.
But the legal
records are to be set right.
My lord.
Where is that finding?
My lord, internal page 4, my lord, last 6 lines, my lord. Further plea that the legal representatives of some of the judgment debtors, deceased Pendilite, not having brought on record, does not mean the decree will now stand inexecutable, since it can be executed against the said legal representatives by following the procedure of.
They've been brought on record, no.
That has thereafter, my lord, it follows the usual process will follow.
There is substance in the 47. Mr. Rai is appearing. Yes.
Let my learned junior address, my lord.
Why, Mr. Datto? Why are you depriving the court
No.
from your submissions?
I am there.
Yes, Mr. Rai.
Defendant is a petitioner before lordship. The suit filed by my learned friend's client.
But I have a preliminary point, my lord. Lordship may consider, my lord.
Yes.
In an appeal, my lord, an application was filed under Order 39, Rule and 2.
Three judges bench.
Order,
Whether it will be revisable and appellable.
Order 40.
Three judges being.
Three judges bench, my lord. So that
I have points on merit. But
This is a three-judge bench judgment. That was an issue.
There is a saying in Bengali to Baji Noah.
The reasoning is it's in an appeal.
In an appeal, not in a suit.
In an appeal,
Order 43 does not apply.
Order 39, Rule 1 and 2.
interlocutory orders in a suit, but appeal
Because
interlocutory
the,
orders.
yes,
there is-
Order 43 says
In a suit.
in a suit. Order 39.
So it
that
is
is
the appeal is a continuation of the suit.
It has been held that it's not an application order passed under Order 39, Rule 1 and 2 in a title appeal is not
revisable.
Is not appellable. If it is not appellable,
revisable.
Is maintained.
Now, my lord, this is a plaintiff file a suit. My lord, I'm drawing a what is the prayer made?
Yes.
Suit for declaration, can you turn to page 55?
The impugned order, Mr. Rai.
I like to hold election, annual jail meeting. I am coming. I'm coming.
General meeting, it is a statutory requirement to hold the annual.
When is the meeting going to be held?
11th.
11 June.
16th is the date for delivery of judgment. I'll come. If the meeting is here, if the meeting will.
Mr. Rai, why are you getting agitated? Why are you straining your voice? We have given a microphone in front of you.
That is the problem. We are not used to that. We have
Your voice is enough.
Please don't strain your voice.
এটা পড়ে যাবে।
Yes. 16th what will happen?
Delivery of judgment of the appeal.
Of the appeal.
Yes. And in the meantime, my lord, if this meeting is held, entire appeal, entire proceedings will. Yes,
An interim order passed.
What is the prayer made? That is why the presuppository, my lord, I am drawing lordship to the prayer. Page 55. Got it?
No, Mr. Rai, 16th is for argument and judgment. Not
Initially,
delivery of judgment.
Previously, it is delivery for judgment, and against it is argument has been closed.
Argument has been closed, yes.
Page 55.
Page 55.
Yes.
Yes.
A decree for declaration that the plaintiff number 228 are duly elected governing body members of the plaintiff number 1, who is the mod, that is a mod in question. And as such, they are entitled to remain in control, position, custody, management, and administration of the plaintiff number 1, and or all the branches, mod, temples, land buildings, and other property affairs. Well, got it.
Yes.
And second declaration, not entitled to act in terms of the purported resolution dated 19th March 2018. This is
Yes.
now, my lord, kindly consider on the basis of which for the trial court held. Kindly turn to page 218.
218.
Last portion, issue number 7. What is issue number 7?
This is the trial court's order.
Yes, judgment. Page 218, issue number 7. It is
Issue number 7, yes.
It is the contention of the plaintiff that such and such retains his post of Acharya of the said mod throughout his lifetime and expired on such and such. But he tendered resignation in the meeting dated such and such from the post of General Secretary. His purported resignation letter was also marked Exhibit 16. However, on the other hand, the defendants have alleged that such and such continued with the post of Acharya, as well as General Secretary of the mod till his death, and purported resignation letter is a fabricated piece of document. A serious doubt arises regarding the resignation letter because entire fact of resignation given was kept outside the purview of the pleadings based on which plaintiffs brought this suit. Moreover, even the written execution of PW1, the fact of such resignation did not find any mention. It is only at the later stage during the prosecution of PW1 when the fact was for the first time brought before the court. No attempt was made to incorporate the said fact by amending the pleadings. During the examination of Peter-Luban, the resignation letter was tendered into evidence. During the constitution of Peter-Luban, authority of Exhibit 16 was challenged, but no further evidence was given to prove the signature BP Yati Maharaj. The Peter-Luban alone affirmed such a signature and no other witness came forward to reaffirm the same. It is a civil suit which is to be proved by preponderance of evidence and following principle of civil law. It is the general principle of law that a fact does not find in the place of the pleadings cannot be proved on the merits. Even if the concrete evidence could have been laid to ensure the authenticity of Exhibit 16, it would have been difficult to rely upon the same because no mention about the fact made in the plaintiff itself. As such, it cannot be said that BP Yati Maharaj actually ceases to remain General Secretary of the plaintiff mod by way of his existence before his death. As already stated, the plaintiff have tried to prove that plaintiff number 2 was acting capacity of General Secretary and Acharya on the basis of some publication, but it must be kept in mind that publication is made by the mod itself and it is very likely to have been controlled by powerful regime. Therefore, the evidentiary weight of those publications must be critically evaluated. As such, the issue decided against the plaintiff. Next, the plaintiff relies upon the present suit, relief number 1, declaration that the plaintiff number 2 to 8 are duly elected governing body members of the plaintiff number 1 and are entitled to remain in control position, custody, management, and administration of the plaintiff number 1.
This is issue number 8.
Yes.
Yes.
Temples and buildings and the property affairs. From the discussion made while the issue number 4 and 5, it is clear plaintiff to have failed to bring cogent evidence to prove to how and when he became the governing body members of the plaintiff number 1. As such, the plaintiff is not entitled to get this reliefs. So the claim of the plaintiff regarding a General Secretary was turned down by the trial court. Now, my lord, kindly turn to page 222.
Yes.
22. The 7th relief of the appointment of receiver and the 10th relief is for receiving power of the court to grant any other relief related to entitled in law and equity, on the basis of which a receiver was appointed under whose control the election will be held of this month. This was the degree. And in their manner, we are also restricted.
Appointment of a receiver.
Yes, allowed. And we are also restricted not to interfere with the management of the mot itself.
No, so the receiver was appointed for the purpose. Where is that?
Page 223.
223. Show me that portion.
The plaintiff themselves, 1, 2, 3, 4, 5 lines from the bottom of the first paragraph. The plaintiff themselves had prayed for an appointment of receiver. And it appears to be the best possible interest of the plaintiff number 1 that the receiver be appointed in a fresh election.
Under the supervision of the receiver.
Yes. So this was the suit.
Yes.
So the suit was.
So plaintiff has preferred an appeal.
Plaintiff preferred an appeal.
Yes.
Now, my lord,
now what happened in that appeal?
In
that appeal, you filed an application.
They also filed a cross objection.
I also
cross objection to the yes.
Yes.
Now, who has filed that application which has been disposed of by the?
No, before that, Manor, can you turn to page 234? It's not 234, begging kindly, Manor. Can you turn to page? The order passed page 225, Manor, once.
Page 225. Yes.
This interim order was passed by stay the operation of the appointment of the receiver for the purpose of holding election. My lord, got it, that portion. Last but one.
225. This is the order under challenge.
No. Because
we filed an application in our appeal and the appointment of receiver has been stayed. The effect which the receiver was empowered to do, that has been stayed.
So the status of the plaintiff was not been stayed, be as it may. Now, my lord, can you consider taking advantage of the same, my lord?
No. Show me the prayers in the plaint. Page 223. No, 223, it says the portion you have placed just above the ordering part. It says the plaintiff themselves have prayed for appointment of the receiver.
And it appears the best
in the
possible.
plaint.
Plaintiff prayed for, my lord, in the plaint itself, my lord, your lordship will find.
55, the prayers.
No, so how this prayer was made?
No prayer as such, my lord. Normal prayer in a suit, my lord, when we make a prayer, receiver injunction, that's there, court has appointed a receiver.
So that prayer was there.
No formal prayer G.
There also.
Normal prayer, my lord.
So
there is no specific prayer.
Now, my lord, taking advantage of this order.
Address, my lord, I would take
Yes.
only 10 minutes.
My lord,
Prayer G, page 59. No specific prayer for receiver.
I'm not on that also now, my lord. Can turn to page 226. That is the E. Taking advantage of this order, the plaintiff started declaring to the secretary and started normal functioning of the said mort. We question because the status of the plaintiff has been negated by the trial court, the degree is still subsisting as jail secretary. Now, my lord, considering the same, my lord, what the trial court have said, can you turn to page 234? That is the important order.
So this is the application 151 filed by them.
By me.
By you.
By my client. That taking advantage of the order of stay, they started themselves to be projected as the secretary.
So what was your prayer? Direct the appellant plaintiff number 2 not to use his individual status.
He is claiming to be the.
So this is in terms of the observations made in that 7th issue or 8th issue.
Issue number 8.
Yes.
Now, my lord, can you turn to page 234? London advocate, the above respondents, my lord, got it?
234.
Yes.
Mr. Rai, how long you will take?
10 or 15 minutes. If somebody, I'll come at 2.
Because the matter of Port Blair has been fixed.
Yes, I will come back at 2. I'll come back at 2. Can do have
For me, my lordship can allot 10 minutes maximum.
Yes.
Maybe less than.
There was no difficulty. He's waiting. He has come from Port Blair. That is the difficulty.
Takes it by 2 p.m.
Yes, well, I'll be here.
After, my lord, the Port Blair matter finishes up.
Yes,
We have
my lord can take at any time when your lordship asks, I'll be there.
Some of the determination of Justice Kant has also been some matters are.
Because if it is held, the entire things will be gone. That is precisely my argument to us. Now, my lord, can you consider as your lordship please as well at any time?
But you continue. How long you will take?
I'll say 10 minutes, I'll complete.
All right. Yes.
Within 10 minutes, I'll complete.
Yes.
Now, my lord, can you consider page 234?
234. Yes.
Last paragraph. No, I'm not skipping the first portion. Last paragraph. On perusal of the impugned judgment. My lord, got it?
Yes.
It appears that the suit learned court has framed for it. Number 4 as to whether plaintiff number 2 to 8 are duly elected governing body members of the plaintiff number 1. And issue number 6, whether the defendant number 1 is the Acharya and president of plaintiff number 1. In deciding those issues, the learned court decided the issue number 4 against the plaintiff and issue number 6 in favor of the plaintiff. Thus, it appears in terms of the decision of the learned court, the appellant plaintiffs have failed to establish their status as the members of the duly elected governing body of the appellant number 1. I got it. Therefore, it is crystal clear that appellant number 2 cannot legally claim himself as the Acharya and jail secretary of the appellant number 1 mort. But from the impugned degree, it also becomes clear that learned trial court has restrained the respondents from interfering with the present office bearers of the allegedly duly elected governing body till the time of election of governing body members. Office bearers follows the correct procedure, and for that, the learned trial court are also appointed receiver. In view, next, my lord.
Yes.
In view of the above, it appears to the court that in terms of the impugned judgment, appellant number 2 has authority to act as Acharya jail secretary of the appellant number 1 mort till election of the regular governing body members. Members to be conducted by receiver. But his position is completely acting till election, and appellant number 2 should mention his designation clearly as acting Acharya and acting jail secretary instead of Acharya jail secretary. So it is only for the purpose of officiating. He has directed. It is categorically clear. It was held by the appellate court that it was directed that he cannot fail to that he failed to prove to be an elected jail secretary or the Acharya. Now, my lord, can you turn to a letter was purported to be issued 238.
Yes.
On letter date 25th, 4/2025.
Yes. So this is issued by that
acting Acharya.
Acting Acharya, yes.
Now, my lord, can you consider the Agenda number 5.
Election of members.
Yes. Now, my lord, can you pause there for a moment? And
Now you filed another application.
yes, because in view of this, now, my
It has been disposed of by the impugned order.
yes, allowing.
Show me that. What is the reasoning? Please show me, because the earlier is the facts, I think. Please
Now,
show
my
me
lord,
the
turn to the
reasoning part.
yes. On going to the order number
Which
16,
page? Which page?
the last page, my lord, 525.
No.
Certificate copy.
Oh, this is not the certified copy.
No, it is a server copy.
All right. So, but it's not.
Dated
My
5th May.
copy has not been favored with paginations. That is the only.
Also, my the last document.
Last document.
Dated.
This is the impugned order, so it,
Mr. Roy is very busy.
no, not me. My lord, my clerk.
Yes, I have no time.
The clerk had the impression that the impugned order should not be petitioned. This was I had said. That's why.
So what is the date of the impugned order?
5th May.
Of May.
5th of May. Last 2 pages.
Yes. On going through the order number.
Yes. 64 dated 20th 4/2021 passed the Learned Trial Court. It appears that defendant number 8 of the suit has prayed for staying the operation of the notice that such and such for restraining the plaintiff from the suit holding AGM. But the Learned Trial Court was pleased to reject the prayer after observing from the notice of meeting submitted before the court. It is evident that first 5 years AGMs has been conducted by the present General Secretary from time to time. From the photocopy of the resolution submitted today, also it appears the annual general meeting was held after also on the each years. Both the sides have admitted that the rules appellant number 1 society AGM has to be held within 15 months from the AGM. It appears the last AGM was held on such and such. From these meetings, therefore, I do not find any illegality or attempt to fill up the lacuna on the part of the appellant by issuing notice to hold annual general meeting. Moreover, as per rules, the society, as per the legal mandate of the societies, as per appellant number 2, is bound to call AGM in the 15 months of the. In view of thereof, I am not inclined to allow the petition. Pause here for a moment, and my lord, can you turn to the bylaws memorandum.
So as per the bylaws, AGM has to be held within 15 months of the last.
110. My lord, can you turn
The
to
last, Mr. I have only one thing. Last AGM was held on 21st of April 2024. So 15 months is till July.
Within 15th, I called.
Yes.
And
So
that's the
it's till
statutory
July.
requirement. Statutory requirement.
Yes, till July. So why can you not wait till 16th of May when the appellate court has fixed a date for arguments and delivery of judgments?
May I not address Miller? If he has concluded.
It was 15 months only for that. Going by the recording of the appellate court's order. See, 15 months is still 3 months left or 2 months left. 16th of May, it appears it has been fixed for
Other argument. Argument and order.
Mr. Dev, what is being done, rightly or wrongly, the trial court has appointed a receiver.
It has been stayed by the appellate court.
At the fag end of the appeal.
But may I, my lord, just address?
And when, taking note of this, when 16th of May is the next date. So I will direct the appeal to be disposed of on that.
But may I, my lord, address the court?
What difficulty you have?
I have.
That is being done because that is also within the statutory limit. I will request the learned appellate court to take up that and to dispose it off on May itself.
But may I just address, my lord, on this limited issue? My lord is asking me a question. Why can't my client wait till the 15 months, last day of the 15th month?
No. I'm not asking you to wait till the last date. I'm asking you to wait. Today we are on 8th for another 2 weeks.
My lord,
It will be within 15 months. I'm not asking you to wait till the 15th month. Why can you not wait? Because this is the issue. Because at an interim stage,
That is not
those findings were there and an election.
That is not the issue, my lord, with greatest of respect. An important part has been left out, maybe inadvertently by my learned friend. He has showed that part of the decree where, my lord, the receiver was appointed to conduct the election. Kindly come to that portion. It's a very important thing is there. Page, my lord, 224. He has placed it. For what purpose the receiver was appointed, that is also very important.
Yes, yes.
May I, my lord? Learned advocate so-and-so is hereby appointed as the receiver of the plaintiff and his branches and temples for bringing and defendant suit representing the motive necessary. Realization, management, protection, preservation, so-and-so, and so forth. Then, my lord, if necessary, along with calling for a general body meeting of the mod to elect a governing body. Kindly take note of it. Scope of the receiver. Something, not even if I lose the appeal.
If necessary, along with calling for a
yes.
yes.
For what purpose? Along with calling for a general body meeting to elect a governing body member.
Yes.
That's the purpose. That's the purpose. Please.
Mr. Rai, please allow him to submit thereafter.
I haven't said anything. Just wait and have patience, Mr. Roy.
Yes, yes.
Yes.
Now, kindly see the important part that is also important, which has not been placed. Page 223.
Yes.
Suit was for declaration. Why the suit was filed? Because the defendants were trying to run a parallel administration of a mott. Mott has about 50 branches. There is an Acharya and General Secretary who has to act in terms of the mott. There are many members, so it has got its own reputation. If somebody tries to run a parallel administration of the mott, and that is proved, obviously it will have a serious impact on the society, at least to the public at large. That is why the suit has been filed. Now, considering their submission, everything, there is an
that is on merits. I'm asking you, why can you not wait for 2 weeks? That is why, because the appeal, right, wrong, the receiver, everything may be set aside.
That has been stayed. That has been stayed. And when they filed an application, court, considering everything, permitted me to act as the acting secretary.
Yes, yes. You act as an acting secretary. Mr. Dev, this is the 16th of May, next week. It will be hard. Why can you not wait till 2 weeks? I can request the appellate court to decide. All points will be left open. Otherwise, some observations at this stage might affect any one of you. Affect any one of you.
What Lordship is saying.
Because considering the fact 15 months, it is yet to expire.
May I say this? May I say this? I would say the stand taken today by my learned friend on instruction is slightly frivolous. May I?
Let the appeal be allowed. Let the decree of the trial court be set aside. Please wait for 2 weeks.
Last 3 years I held meeting. During the pendency of the appeal, I held meeting. All were accepted by them. They have
only thing.
They have some ground.
I think only grievances with regard to this election.
And for what purpose? And for what purpose? And for what purpose? Kindly comes to the notice once.
Yes.
What is bothering your lordship, since that is an issue to be decided in appeal and receive. I got your point. And the receiver has been appointed to conduct the election. That purpose may be frustrated, may have an impact in the outcome of the appeal.
Because he is an independent. Because when this is the nature of the dispute between two warring groups. So maybe you are saying he do not have any authority. He is saying you do not have any authority. That's the court to decide finally in the appeal. But what is troubling is receiver is an independent person.
Yes.
None of you have any objections with that.
I had challenged the appeal, only challenging that part. The receiver could not have been appointed.
That is one part. So if that is so, let it be postponed till after the decision of
Lordship, if that is the only part that is bothering your lordship, may I, my lord, indicate, kindly comes to the impugned notice once, page 238.
Yes.
Because possibly this is not touching that part.
Election of members.
Kindly come. Election of members, that is the only part that is bothering my learned friend and bothering this court also.
Yes.
Election of members of what? Not the general body. It's an annual general meeting I'm holding.
Yes.
Kindly come to at the top. There is a lot of difference. I will show you from the provision. This is an annual general meeting. Annual general meeting to elect the members, not the part for which the receiver has been appointed. Page 223.
So not for election of governing body.
No.
If I clarify that.
No. Yes.
What difficulty you have?
On
If it is
instruction, I'm
clarified
saying.
that you will not
I
be
got your point.
with
Absolutely.
regard to that members of the governing body.
Kindly.
That is the
And
purpose.
kindly come to one more document, one page. It may resolve the issue and may cure the anxiety. My lord, kindly comes to the rules and page 118, the specific rules.
118.
118, the rules of the mort. This will make the position absolutely clear. He has referred to the rule. Kindly come to page 118. It's not for electing a governing body member. Why should I do it? Kindly come to page rule 10A. And this argument has been advanced before the trial court. I'm sorry, my lord, page 118. That's an annual general meeting.
Rule
10A.
No,
there
are 2 page numbers.
110. My lord, I have 3 pages, my lord.
110 is better. What have you done?
No,
you are trying to confuse everyone.
No, he doesn't do that. He
Give
doesn't.
me one page to the court.
I not consider it that way. It's not about senior, junior. He's my friend. Kindly takes page 110. Page 110.
Rule 10A.
Rule 10A. And this has been amended subsequently. I do not know whether they have amended, whether they have annexed the amended rules or not.
Yes.
My lord, the page that I am having, which they have given me, that is, my lord, page 138 then. 138. Because the amended rules will have an implication. 138.
138. Mr. Rai, what is the page?
I am having it.
Where I will get?
118.
No, 138.
138.
Slowly. We will have tea together.
Yes, 10A I have got
Yes.
138.
Lordship has got it. Kindly see at the top. There shall be.
This is the amended rule.
That is applicable. Forget about amended or not amended.
So 110.
There shall be one annual general meeting. There shall be one annual general meeting. Not for electing the governing body members.
No, there shall be one annual. So ordinary has been struck off and annual.
Annual general meeting.
Yes.
The association to be called by the general secretary. I am not calling as the general secretary. I am calling the meeting as the acting general secretary, complying the court's order. And he has said one thing, officiating. What does the word officiate means? What has to function? I will not disobey the court's order. I know the outcome.
No, but
clarify this. Clarify.
So if it is clarified that it is not with regard to election of the governing body.
And kindly consider one thing. Kindly have a look at this.
But the governing, but that is why precisely.
Kindly have a look at this. Look at this act, Miller. What is the?
And who is entitled to call the meeting?
I am entitled to absolutely acting secretary. Court has given me.
Getting your chance. Yes.
Yes. Kindly have a look at this. I am governed by this West Bengal Society Registration Act. Kindly have a look at the relevant provisions. Rule 16. Kindly come to rule section 16.
Section 16.
Yes. And there is a penal provision, Miller.
I am statutorily bound.
I am duty bound to hold it, and that's a statutory compliance. I have to do it. Section 16 and 17. 16 specifically. And this part 15 months comes because of the Dol Yatra. There is a festival, my lord, that has been organized in the mort. That's why the extension of 3 months. It's a clear indication in the statute.
Yes, yes. Mr. Dev, even if you wait 2 weeks, this clause will not be violated.
No,
there will be no statutory violation.
I understand. What is bothering your lordship? The one agenda.
Only agenda kept it postponed.
No. 2 things, my lordship can do. Lordship can do. He has to make a prima facie case. Just because he is coming and saying court will not accept, the prima facie case court has to accept.
Yes, yes.
Prima facie case when somebody has been restrained permanently. Where is the prima facie case when the court had permitted me on his application to act or officiate as the acting secretary? Where is the prima facie case when the court has stayed the order of appointing the receiver? Where is the prima facie case when in the last order court has categorically held?
Where is the order of stay for acting for the receiver acting?
Page 225. Page 225.
225. Yes.
These things will have to take into consideration.
Yes.
Page 225. I have made out a prima facie case. That's why it has been stayed. And you are permanently restrained by the decree. And that has not been stayed. Page 225, kindly see, my lord. During the hearing, my lord, last 3 paragraphs I am reading, I am not troubling your lordship.
In view of the above, the
Yes, the learned to be appointed by the judge is hereby directed not to take any further step in terms of the impugned judgment and decree till the final hearing of the stay petition. Stay petition has been disposed of finally, and it has been heard, or in other way, it has not been indicated, heard with the appeal. Now kindly read.
No, where is the order disposing of the stay application?
My lord,
It will be heard along with the appeal. That is why last
for
portion.
fixing the appeal along with the stay application, appearance, rest of the, kindly go by the record. My lord, there is no formal order, but there is a subsequent order on this application, permitting me to act as the acting secretary.
Yes.
Page 234. This has to be read with this.
Page 2.
Page 234. This has to be read with this because on his application, this has been part. Court could have negated my prayer. Could have said, no, you can't act. Court has not said that. Kindly come to the operative portion, page 235, recording the submission. Court has passed this. In view of the above, it appears to this court in terms of the impugned judgment, appellant number 2 as the authority, then what the instead of the what? Secretary court has said acting till the election, so court has permitted me to officiate. And he was correct in saying that. So the acting part is there. And what am I supposed to do? What am I supposed to act? I have to go by the rules and regulations. And what did I do? I just inducted, and I have just given a notice that I will be holding meeting in terms of the 2 orders. They did not get any order. Everything cannot be in vacuum, cannot be in limbo. All these are to be taken into consideration. Now kindly consider the bothering part. What is bothering your lordship, my lord, the court, and also my learned 238. Election of members. Lordship can clarify to that, my lord, that this can be subject to the outcome of the litigation. I would hold hearing if they're so bothered. But I am saying, my lord, on instruction, I have shown you election of the governing body. It's not that. It's not that. Otherwise, it could have been indicated. Lordship can clarify that the election of members means in an annual general meeting when the members are elected. On instruction, I'm saying.
Not the office bearers.
No. This is the meeting. Kindly clarify. What is this? Is the meeting? What is the other agendas also?
Your grievance is with regard to this office bearers, this part.
Yes.
Of the. So he says that will not be done. If I
election of the members, that is the presupposes.
No. Again, what are you saying? Kindly come to that.
To page 110.
No, not 110. Kindly see the decree.
Governing body as well as the office bearers.
Governing body as these members will elect the governing body.
Yes. Yes, sir, the governing body also as well as the office bearers.
Could clarify that. I'm saying.
So what is the problem for sitting as for 2 weeks?
Governing body.
It's not about the problem.
What members will be appointed
in the election? Members in a general body, not the governing. Kindly come to 15.
Show me the provisions in the rules for appointment of members other than the governing body.
Absolutely, my lord. Absolutely. Kindly comes to my lord. 15A. Again, the page will not tally. 15A and 15B.
138.
My lord, may I just, my lord, slightly confused about the pages, my lord.
Mr. Rai is responsible.
No, not at all. He's my friend. I can't blame him.
It is there. He cannot blame me also.
Yes.
Only I have to find out the relevant clauses. There's a lot of difference between the two. Yes. Kindly come to 14B. There is a process for electing a general body.
14D.
14B.
B.
138.
My lord, I tell your lordship what happens. Annual general meeting is conducted. The election means the ordinary members. Now, for governing body, there is a different procedure that has been prescribed, and that has been, my lord, recorded in 14A and B. Kindly see, my lord. Annual general lordship has seen. Now, how the governing body members are elected, kindly see. The governing body shall consist of maximum 15 members, and each of them must have a full members of the association. Then 14B, vacancy and election. If at any time vacancy amongst the members of the governing body occurs by death or by resignation or by severing the connection with the association or by removal or otherwise, the association may, in general body meeting of full members, call for the purpose among its full members a governing body member. So there is a specific procedure for appointing a governing body member. I am not holding the election for electing a governing body member. It's the annual.
Which members you will? Where is that provision for election of members? Which members you will appoint in this AGM?
General members.
Show me that provision. Mr. Datta, show me the provision for the appointment of members in the AGM.
In a society, there are a number of members. Once in a year, members are appointed.
For what?
They become that sannyasis, they become the members.
14D.
It is a-
consider.
it is a
14D.
Kindly consider 14. Mr. Dotto has been conducting, my lord, pro bono this matter. I have also been engaged. That's not the purpose, my lord. 14D. Governing body, general body. It's a lot of difference between the two. He is bothered about the post, and rightly so. That's an issue in appeal. I can well understand. But for that, annual general meeting cannot be stalled. A member of the governing body may be removed from the governing body by 2/3 majority of the general body may be. So there's a governing body and members on the ground of any activities of which is found to be injurious to bar kora that ওই cluster detrimental or stepping of the association before such removal. However, recalcitrant members of the governing body will be suspended from acting or function as the members of the governing body upon demanding from the remaining governing body members of the general governing body. The recurrent member of the governing body will, however, being heard, the remaining members of the governing body of the remaining members of the governing body.
Yes,
This talks about the
this all talks about the governing body. So where is the
there, but let me
provision
just-
for general members? What you are saying?
kindly come to page 108. Dada bolbe.
108.
There is a provision. Governing body members are elected from the annual general meeting, and only the
Governing body members are elected from the general body. AGM.
Yes. Now, my lord, for electing a governing body, there is a procedure how a governing body
When it is appointed. In which meeting?
No.
Lordship is talking about the annual general meeting and the general members.
No, the governing body.
Governing.
Show me the provision for appointment of a governing body.
Before that, kindly see who may be appointed.
As a governing body member. That is
What
14.
Yes. What is the procedure when it is appointed
14B.
and in which
That
meeting?
Acha. That is 14B, my lord. But kindly consider 2A also.
Page 138.
108, my lord, in my
108. 108 is the earlier unamended rules.
Few portions have been amended, few were untouched.
All right, so
still hold good, my lord.
108.
108 rules 1, 2A and B.
Yes.
Any followers, whether lay or monastic, of the Sri Chaitanya Math may be the members of the association if elected at a meeting of the association or nominated by the governing body hereinafter mentioned. A person intending to be a member shall sign the declaration form annexed herewith and submit to the general secretary an application in a form prescribed by the association, and it shall be proposed by the members of the association, seconded and supported by at least 2 members of the governing body. That is the governing body. So this member is not a governing body member. In order to become a member of the MOT, this is what has to be done. And this election has been held on instruction, I am saying, for the purpose of appointing those members, but not the members who would be elected
So
by the
according to you, this was in this AGM, these members will be appointed.
Yes. This is on instruction. And 14B says about the governing body members. Kindly see, there is a catch in 14B. Full members.
No, but I think 2A clarifies it is at a meeting. It's not AGM. These members cannot be at AGM. Subject to correction by you.
May I?
One minute time maybe even to be.
My lord, kindly clarify that. I tell you.
Two-third, my lord, this is.
Hey, John, wait a minute. My lord, kindly clarify. My lord,
Okay,
yeah.
clarifies, my lord, that
Unnecessary, the
that will not be.
court is being confused, my lord, by making this type of submissions. My lord, an association is run by its members at large. Out of the total members, some members are being appointed as the governing body members. That for the appointment of the governing body members, the procedure is mentioned there. Now kindly come to page 1081.
Yes.
What is the procedure for making an application to become a member of the MOT?
Yes.
My lord, lordship has seen 2A, B, lordship has seen 1. Heading, members declaration form. I look upon Sri Chaitanya Dev as an embodiment of the.
So this is the declaration form. We did not go into
This
that.
is the procedure.
Yes.
Every year, once these members are taken. That is on Dol Jatra Day. That day has been now changed up within the 15 months thereafter. So therefore, these are the all general members. the court, the trial court has restrained from holding any general meeting and the governing body meeting. And the agenda which has been shown to your lordship, it is an election of members. It is not the election of either governing body members or office bearer members. If there is any doubt in the mind of the court, I invite the court, my lord, to get it clarified. The whole application which was filed before the appeal court, that I do not have any power to call the meeting. Now here the point has been taken otherwise.
Yes, yes.
My lord, kindly clarify. I am requesting your lordship to avoid all confusion. To avoid all confusion, my lord, kindly clarify that I can hold this meeting, but this meeting must be confined to not this governing body or the office bearers. And my lord, this type of meeting during the pendency of the appeal had been held 3 times in last three consecutive years. And there was no complaint, nothing of the sort, and that is what the learned appellate court has mentioned.
Request of restrict to my learned sir.
Please, I
No,
will get finished. Please.
whether any election agenda was there in the previous meetings or not.
Whether it is not there, not there.
With the
Yes.
page, relevant page. My lord, I got the relevant page, my lord, now. Page 110, possibly. I used to excited on. Meeting of the association.
10B.
10A.
10B.
110.
5.
She has got it.
5.
110 10B. I have looked at that.
General meeting.
5.
I have looked at that.
Election of members, does
Yes.
it qualify? Does it say? It's a governing body. Members? No, kindly clarify this. I am holding the meeting in terms of this clause for the purpose of electing members, not the governing body. Now, how the governing body members will be elected, that is 14B, 2/3 full members. Has that been qualified in 10AB? Has that been, where is that?
And I am not holding that.
10AB, yes, absolutely, 10B, members. Now kindly read this with that particular page, which says the appointment of governing body members, which is bothering him, and court is absolutely right. When this issue is there, how can that be done? Kindly read that 14B. Is it
Yes.
the same clause for electing a governing body or a removal? Kindly see this.
Yes.
Clarify this, if that's the one thing. But you can't stop me.
Yes. Yes, Mr. Anything.
Absolutely.
Only one thing I am satisfied, Lordship, what my learned friend wants to submit. What the election is there, only your Lordship find 10B. 10B.
Which page?
That is at page. And turn to page 110.
Yes, 110. Election of members. Mr. Rai, you are concerned. Only one thing.
No, election.
According- But that will be the dispute decided. So now they say, kindly consider this. According to you, this
Annual
election of members is not for the purpose of, please come to page 223. The trial court's judgment.
Governing body. Very
Yes.
So you are only against this, that only the receiver has been appointed and a fresh election for governing body as well as office bearers. So this is the trial court's judgment. So they are saying this will not be transacted. I will record their submission.
Politically consider how, what authority they have to call for the general meeting.
Authority is the acting, the court's
For
order.
the general meeting, AGM.
Yes.
No, Mr. Raj.
AGM.
Now, you started with saying for the election.
Yes.
Now, so election, there are in the AGM, various other businesses will be transacted.
Yes.
So receiver was not appointed for that. Receiver was appointed to hold the election. So one agenda is with regard to election of members. According to you, this is in violation of page 223.
I am not on that. I am on the basis fact whether any meeting can be called by this person who has declared to be failed to prove that is a.
Where is the bar?
Yes, that is why precisely
that means the acting.
So
That means
yes.
that means the acting Chief Justice If there is an acting Chief Justice, cannot hold the administration, cannot write a ballot.
So you have, let him give his reply. Yes.
Your Lordship will find 10A. There shall be one ordinary general meeting of the association to be called by the General Secretary every year on the first Sunday of the September, soon after they as possible, but in no case later than 15 months. So this is 10A. This is the ordinary general meeting. Next, my lord, is the annual general meeting.
Yes. 10B is annual general meeting.
This is annual general meeting.
10B.
10B.
Yes.
The annual general meeting of the following business shall be transacted, including the election of members.
Yes.
Such other business, not less than 20 members. So therefore, what my learned friend is a 15 months period, that is the ordinary general meeting.
And what is the time limit for this AGM?
Just for 15 months, 10A.
10A is for ordinary general meeting.
Annual, the word annual is there.
No. 10A annual is not there.
What is there?
10A is for ordinary general meeting.
No, what? Well, kindly have a look at my brief, my lord. Maybe 138 pages not tally. I'm handing over, my lord.
No, I'm looking at 110, 138.
No, 110 has absolutely has to be read with this.
138.
138. And there are other clauses also. This will be clarified. Yes.
Oh.
Mr. Doctor has pointed me out, sir.
Mr. Rai,
Yes,
may not be 110, 138. 138, yes.
And there is one.
There shall be one
138,
ordinary.
there has been an amendment.
Yes.
So this is AGM.
The one ordinary general meeting of
No. Ordinary has been
absolutely
struck off. It has been made annual. It's my copy is also that.
Yes. There shall be
not
annual general meeting.
Yes.
The association to be called by the secretary.
Yes.
Such and such. But in no case such and such. So the ordinary general meeting has been called annual general meeting. The governing body.
No. This is annual general meeting for 15 months.
Yes,
not
annual
ordinary.
meeting.
Yes.
It was ordinary general meeting.
It has been amended now.
Really. The fitting association will be called by the General Secretary every year during the festival of Dol Jatra, but not later than 15 months of the previous years. Meeting of such place, date, and hour of the General Secretary from time to time, maybe daytime.
Yes.
The governing bodies are constituted and 15 members of each member must be full members of the association. So these members who have been selected will be voting for the purpose of formation of governing body. So
Mr. Rai, they are saying that will not be done. If that is.
these members will be selected by this election. Otherwise, then what is the purpose of election?
Which members?
The members will vote to the governing body.
No, not.
How do you get that?
Yes, my lord, can you turn to the next portion?
15A. One more clause.
Yes, I'm coming to that.
Make the position clear. 15A. 14A, B, C, 15A. How the governing body, lordship, will not ask me kindly say. How the office bearers are elected and how they will hold the meeting.
একটু বলবো
Page 112.
হয়ে গেলে তাই বলবো
না আমরা সবাই বন্ধু কোনো দাদা নেই you and me and we all the same boat.
Yes
15A.
না মানে no ঠিক আছে হয়ে গেছে
Yes Mr. Rai.
আবার নতুন
Yes Mr. Rai.
Yes. Now the confirmation of the proceedings. Now my lord, can turn to not less than 20 members shall form a quorum in the meeting of the association competing to proceed with the business of the meeting. Not less than 15 days notice shall be given to the member of the meeting.
Which page you are placing?
111.
111.
Yes, 11B.
11B, yes.
Not less than 15 days notice shall be given to the members of a general meeting of the association. Such notice together with the agenda shall be drawn up by the general secretary and sent to the post of the registered address each member. Date of posting also is deemed to be the date for holding meetings. And non-receivable notice can be no business with no agenda matter. I am skipping over the same.
What is that?
Yes.
And a little the senior council matter.
We are friends.
Friends is something else, my lord.
Yes
Act
Mr.
is
Rai.
something else.
Yes Mr. Rai. Yes.
Now, my lord, can you turn to 14A? Next page, 112.
Yes. Mr. Rai, 14A has been amended.
Yes, I am carrying both the.
So you come to the amended one.
Yes.
Because
14A. If you're logical, turn to page 139.
138.
138.
Yes.
138.
Yes.
Sir, আপনারা ইয়ে করছেন তো
Yes.
14A, 14A. Yes. The governing body shall consider 15 members. Each of the members must follow only the full members of the association. If any time vacancy. 14A, B, C.
Yes.
Now, my lord, can you consider who will permitted to vote in the annual general meeting? This is the main thing. Who will elect the office bearers and annual general participate in the annual general meetings? Whether the members who have been elected, they will participate in the annual general meeting for the purpose of the governing board. Consider trial court have held, there is no general secretary. They failed to prove the general secretry. Today, if the meeting is held, my lord, can you consider today the meeting is held
By permitting me to act as the acting.
Yes, precisely that was hijacked from me. That argument, I want to satisfy what is the acting and what is the officiating. But that question was put forward. This clearly came up not before this honorable court, but
44 branches.
Yes, Mr. Rai, only one thing, page 225. Is it under challenge?
no.
You are not aggrieved by this.
During the line of both the sides submits 42 branches of appeal.
This is not under challenge, Mr. Rai.
Not to take any action in favor of LTR, fix hearing of the appeal along with stay application. So today, my lord,
No, no, I'm asking you, this is not under challenge.
now my lord, considering the same because this was not challenged and they are taking advantage of the same. I have placed before the application for the trial court. What is my case? That you did not act as a secretary or president. My lord, can you consider that order? Page 234. This is presupposedly the order which is standing in their way also. Page 234.
Yes.
Last paragraph.
Yes.
On perusal of the impugn judgment, it appears that the suit learned court has framed 4 issues as to whether plaintiff number 2 to 8 are duly elected governing body members of plaintiff number 1. And issue number 6, whether the defendant number 1 is the Acharya, and whether defendant number is the Acharya and president of the plaintiff number 1. In deciding those issues, learned trial court decided issue number 4 against the plaintiff, issue number 6 against the plaintiff. Thus, it appears in terms of the decision, learned trial court appellant plaintiff has failed to establish the status of members of the duly elected governing body and appellant number 1. Pause there for a moment. On the basis of which the trial court has participated, you cannot act as claiming to be the secretary and secretary, you are acting. Now, pause is here, what is the effect of a jail person who are having the substantive post and the acting?
Yes. Yes, Mr. Rai.
This much of protection is junior counsel commands expect from the senior counsel.
Mr. Rai, you are sufficiently
No, my lord. Junior?
seasoned advocate.
I'm junior.
So you should not get distracted on the side comments.
What we learn from the seniors, my lord.
But you should not get distracted.
No,
So you have sufficient practice behind you.
This
So-
came up for
Yes, yes.
Out of the game.
Yes, yes, Mr. Rai.
This is 2000 SCC online Karnataka page 698. Kindly, I'm drawing your attention to what is the হ্যাঁ আমাকে বলতে দাও তখন আমি বলে দিচ্ছি আমি দিয়ে দিচ্ছি এক্ষুনি অফিসিয়েটিং বললেন না অফিসিয়েটিং অ্যাক্টিং
আমি অফিসে যাও
Which paragraph,
Yes,
Mr.
my lord. Yes. My lord, can you turn to paragraph 11? So this relevant portion special legislation RTI in NSAB makes it clear the power assigned to the time of schedule the stage carriage permit respondent number 3 was specifically delegated to the secretary RTA as none else. In view of the matter, the respondent was in charge secretary RTA as a material time could not be treated as the official secretary proper. Therefore, respondent could not have acted as delegated as a power as they had no legal authority to do so. As such, the order issuing timetable has been quashed. এখানে একটা অফিসিয়েটিং এই যে এইটা না অফিসিয়েটিংটা কোথায় গেল প্যারাগ্রাফ 10 নি তো
বুঝতে পারবো আমি দেখতেও পাচ্ছি
if you lost again turn to paragraph 3
3
yes my lord I beg to be corrected. Skip over to next page.
Yes.
First, the where it is laid down, my lord, last portion, your lordship.
Officiating appointments and in charge.
Charge arrangement, as well as understood in terms of civil service. When the officer is appointed to officiate in a higher appointment, he invested with the power of the higher post. But when he is placed in charge or current duties to vacant posts in a higher appointment, where the addition to his own independently cannot exercise any of the statutory powers of the office, he can merely perform a day-to-day duties only.
Motor Vehicles Act.
Yes, anything more?
So,
anything more, Mr. Rai?
So, if you logically consider today, in any event, if this election held and the members have been elected who will go to vote to the jail body, what will I put this question, what will happen today? In the suit and
Clarify that part. This bothering part, Lordship would clarify.
No, the election of members only in the annual jail meeting, my lord.
When is that meeting?
Tuesday.
11.
Sunday. You have any 3:30 today? No 3:30.
We will not follow. We'll come.
You have a 3:30 today?
Yes, we have, my lord. Possibly a notice has been circulated. I have, my lord, got that post.
All right, so I will deliver this judgment.
After
At about 4. It may be 10-15 minutes here.
And my lord, one thing, my lord, it's my duty to point out, my lord.
I'm keeping this book.
Absolutely. My duty is to point out. Kindly, my lord, comes to the order that has been passed on 24th of April. My duty there, the next date.
24th.
The 24th April. This is not the impugned order, but the order passed in trial court. 24th April 2021, order number 64.
Page.
But that's not been paginated. That's not been paginated. 249, then there are 250 possibly. Just have a look at
order
this.
dated?
24th April 2021.
24th or 20th?
20th April 2021. I'm sorry. Yes.
Order number. I've got that order. Yes.
Summon substances, my lord. Before the trial court, identical prayer was made, restraining the secretary. At that point of time, acting was not there to hold a meeting. Trial court negated.
No, but thereafter the decree was passed.
Yes. Correct.
So the decree. So what is the effect of this interlocutory order after the decree has been passed?
But that order has not been challenged with the
maybe. But what is the
March? Interlocutory orders march with the decree. I got.
Lordship, item 261, your lordship. It has been mentioned in the morning, your lordship, was pleased to fix it at 1 p.m. your lordship. The interim order is expiring today.
interim order is expiring? Who is for your other side?
Your lordship,
And my lord,
Mr. Trivedi is here.
Yes. Where is he? Extending the interim order.
I had suffered this interim order on the 16th when I was
Mr. Trivedi, there is one
sword is dangling on my head because on my ground, my lord,
extending it for a limited period.
My lord will kindly extend, but my lord will kindly understand my problem. My lord, we have taken out a vacating application.
Right, I'm fixing.
My lord will kindly fix it next week, my lord, any day, my lord, because not after vacation.
Not late.
Then, my lord, I'm because
why?
Lordship, the week
1200
Then
days
it will not be extended. Let it remain. Let me see in the next week.
Lordship, can I make my
My
submission?
lord, 46 lakhs award passed in 2014.
If it is taken up in next week.
Next week, your lordship, I have personal difficulty.
My lord, I had personal difficulty on 16th, my lord.
Lordship, the week after that.
They pressed this interim order, my lord.
The week beginning 19th, your lordship. It is
I had
that week not be available.
Lordship, I have some emergency. Your
My lord, on 16th, my lord, when there was a holiday only that day, my lord, interim order was pressed for.
We did not oppose the prayer, your lordship.
And my lord, my lord, now sword is dangling on me, my lord. Award passed in 2014. In those days, my lord, in award, no, for staying in section 34, there was no terms. 112 days delay. 112 days delay. They took time for
your lordship. It
my
was
lord,
not an ex parte order, your
my lord, my junior was there. It was paid, my lord. I am not opposing, my lord. Next week, my lord, let me argue, my lord. Whatever.
She has difficulty. I'm keeping it on 19th.
19th, your lordship.
My lord will kindly keep. My lord will kindly keep it, my lord, because my lord, I am personally, my lord, beseeching my lord, because that day 16th, my lord, what has happened? It has gone in
the last order.
Yes, my lord. It has gone in the order sheet, my lord.
What?
That, my lord, prayer has been made on my ground. But in spite of that, that prayer is being rejected and Milord, interim order is being granted. So Milord, Union of India, Milord, that is what is Milord pinching me the most. Milord, sort of debacle is hanging there. And today again extension without a notice.
No, my
To my junior. Where is the junior? Notice has not been given to my junior. I am sitting here at the.
2 minutes.
Have you notified?
No.
Lordship, the AO, Lordship, she refused. She refused,
Yes,
Lordship.
call the next matter.
Lordship, she refused. We have
Maybe.
been.
File an affidavit. File an affidavit with regard to that. That he has refused.
Lordship, kindly.
Who went to tender? File an affidavit of service. I refuse. No. To the learned advocate. Please file an affidavit of service. Please file an affidavit, not by producing that person. Ask him to file an affidavit with that regard.
On the corridors, I was intimated.
Yes.
On the corridors, I was
intimated.
Yes. Please file an affidavit. Monday it will be taken up. Tuesday. Yes.
All right.
Just one second. If it's Lordship desire, Milord, then we can Milord, produce the 3 copies of the annual general meetings, Milord, which were held and handed over to the court, Milord, if Lordship wants.
No, I could not follow. Yes, what is that?
The impugned order records the fact last 3 years also we held the meetings.
Yes.
So those were handed up to the court because we're not annexed.
That is not necessary.
I have this, Milord.
Yes, call the sorry, there is some delay.
That's fine. No. My lord, I am appearing for the state respondent, my lord. My lord, I object to the maintainability, my lord, of the petition.
I have a right to.
No, I am raising a preliminary objection, my lord, with your lordship. My lord, they have challenged and the show cause.
Right.
They have challenged, my lord, a show cause notice. And my lord, the show cause notice only asks them to appear before the authority and make their submissions, produce documents. And my lord, after the show cause notice, in case it is confirmed, the order is appealable. Now, my lord, they are already injuncted by an order of civil court. My lord, therefore, my lord, there is no, writ is premature, my lord. The authority has mainly kindly see the impugned order, my lord.
What is the
at page 77, my lord, kindly turns to page 77. It's in the form of a stay order issued by the executive engineer planning. I'm just placing it, my lord. I'm prejudiced by paragraph 3.
So kindly see, my lord, the page 77, my lord. This is only a show cause notice, my lord.
I'm coming to that. I'll place everything.
And once the show cause notice is confirmed under regulation 32.10, 32.10 of the regulations, after that it becomes appealable, my lord. So, my lord, they have come at a premature stage, my lord, and they are already injuncted by the civil court. They have themselves admitted in the writ petition.
Give me a minute.
My lord.
Yes, Mr. Jayapal. So you have been asked to appear before them. Did you appear before them?
It's not so simple, which has been argued by Mr. Chakraborty.
No. I'm not on the argument of Mr. Chakraborty. I'm only the stay order.
My lord.
Mr. Jayapal, only a stay order has been passed.
My lord.
It's a prima facie observation. The prima facie observation is that the building is in contravention with certain provisions of the relevant regulations.
My lord.
So you have been asked to produce documents to appear before the authority. You appear before the authority, satisfy that authority that you are doing everything legal.
That if I could show that the officer who have issued page 77 has no jurisdiction under the municipal council, then I'm well maintained, because there is judgment of Supreme Court which says even a show cause notice issued by an authority having no jurisdiction can be assailed in a writ court. I can place that judgment of the Supreme Court. There cannot be any debate on this point. This executive engineer planning, kindly appreciate one thing. He is not.
Jayapal, I will give you liberty to raise that point also. What is the next date fixed before the authority?
No date has yet been notified. The problem.
Yes, Mr. Chakraborty,
one thing.
When can you give him an opportunity to produce?
Kindly appreciate.
My lord, whenever, my lord, no difficulty. My lord may fix a date. My lord may fix a, because that has gone to the tehsildar for demarcation. So to produce that report. So my lord may fix a date. My lord, let him appear. My lord, no difficulty. My lord may fix a date.
Well, give me a suitable date to both of you.
May I say one thing? Lord, kindly appreciate one thing.
Kindly see paragraph 6 of the writ petition. He himself admits there is a stay of civil court.
From
Mr.
the
Jaipal,
It is on 26th May.
26
would be
May,
a-
Ms. Nag is appearing. She has informed.
I am appearing for the private respondent because I am the neighbor. He has carried out the construction covering the setback area as well as the footpath.
Please give me a minute. So
Your
this
Lordship.
the order passed on 15th of April 2025. You are directed to appear before the authority on 17th of April 2025. Maybe you have challenged, you have raised a question of authority of that particular officer issuing this.
My lord.
You raise all those points before that authority and you also satisfy that you are doing everything legal.
Lord, this order was passed pursuant to an order of the writ court. I challenged both the orders before a division bench. My lord, pursuant to the liberty granted, I filed this writ application challenging this stay order.
No, Your Lordship.
Kindly consider this
No
judgment.
such liberty was granted.
The order of the writ court, my lord, I'll show at page, I'll show in the writ petition, the order in simpliciter. I have challenged the order because the order of stay was issued pursuant to the order of the writ court. I'll show that.
Writ court only said to consider the representation, my lord, of the private respondent.
I've been done. Why stay order, my lordship? I am asking myself.
Anyway, I am not concerned with that, my lord. That is a private dispute.
Once, I am carrying out my work or my recorded property based on a sanction plan issued by the municipal.
Mr. Jaipal, you will be, because you have not been allowed to construct for 1 month.
My lord.
For 1 month,
My lord.
I'm fixing a date. Next week, you appear before the authority. Satisfy the authorities.
Already, our island is experiencing monsoon. It would last till November. My lord knows. Once
Next week, Mr. Jaipal, next week, any day, subject to convenience of both of you.
As Mr. Chakrabarti
Mr.
suggested.
Chakrabarti, give us a date.
No, Miss Nag informed, my lord. Miss Nag is appearing for the private respondent. She just
Mr.
informed it is
Jaipal, yes.
26 May it is
Mr.
fixed.
Jaipal has no difficulty. It can be fixed on 26th because I am out of station up to 25th. So if it is fixed on 26th,
no, this is only
it would be appropriate.
Will appear before the authorities and produce these documents. It's not for the hearing of this matter. So that is why I am asking.
Then is no issue.
Whenever, my lord, no difficulty. Whenever your lordship fixes, my lord. Whenever your lordship fixes, we have nothing to say on that.
Date and time next week.
Any day, my lord. Any day.
16th. At what time? What is the most convenient time? 12 noon?
Yes, my lordship. 12 noon.
My lord may fix, my lord. I frankly don't know, my lord, what will be convenient for the authority.
That is why I'm asking Mr. Chakraborty, so that the authorities will say, no, that time is not.
No. Once my lord fixes, my lord, they are duty bound, even if it is 4 AM in the morning, my lord, they will do it, my lord.
At daytime, their working time on 4 PM will be convenient for the.
4 PM. 4 PM, the officers will not say that it's 4 PM.
No. Once there is an order of court, that will be my content.
I have no problem at all. I have no problem.
So I'm making it 3 PM. I think that will be ideal. So, Mr. Jaipal, I'm disposing it off by giving you liberty to approach the.
And all points which I have raised in the.
Yes. All points. Mr. Chakraborty, learned senior advocate representing the Andaman and Nicobar administration, raises a preliminary objection as to the maintainability of this writ petition. Mr. He submits that by the by the stay order dated 15th of April 2025, the executive engineer, what is within bracket PLG, planning, bracket planning, municipal council, only directed the petitioner to appear before the executive engineer on the date and time specified in the said order, along with relevant documents. He submits that a decision of the authority on such issue is an appellable order under the regulations, under the relevant regulation. He therefore submits that the writ petition is a premature one. First paragraph. Mr. Jaipal, learned advocate appearing for the petitioner, submits that the petitioner is raising construction after obtaining sanctioned building plan, and the same construction is not in violation of any regulations. He submits that the executive engineer do not have any authority under the relevant regulations to issue such an order. First of, however, without entering into the merits of the claims and counterclaims raised by the respective parties, this court is of the considered view that the interest of justice would be subserved if the petitioner is allowed to appear, the petitioner is directed to appear before the executive engineer planning municipal council, being the respondent number?
It's respondent number three, my lord.
Being the third respondent in this writ petition on 16th of May, 16th of May, on or about 3 p.m. Along with all relevant documents, namely copy of the approval of the building plan, land record showing the ownership over the land in question, and demarcation report, if available, etc. First up, it is however made clear that it will be open to the petitioner to raise all points before the executive engineer planning at the time of hearing on the issues raised in the order dated 15th of April 2025. First up, paragraph. Yes, Ms. Nag, you are representing whom?
I am representing the private respondent, Your Lordship, the Urmila Adhikari.
What is your submission?
My submission is that my submission is that, Your Lordship, he has violated the building plan. He has carried out the construction violating the setback norms, and therefore I also should be given.
Yes. So you have lodged a complaint. Pursuant to a complaint, this order was passed.
Yes.
উপরে
Yes, Your Lordship.
এটাতে করেছি না, সেখানে একটা লিখে দেবেন যে Ms. Nag, learned advocate, appears for the fourth respondent. She submits that the petitioner hearing is raising construction in violation of the building plan and the rules of the relevant regulation. Submits that the fourth respondent has lodged a complaint in that regard before the competent authority of the municipal council, pursuant to which the stay order was passed. ঠিক আছে, এবারে লিখে দেবেন to appear before the said authority on such and such date. The executive India planning municipal council, being the fourth respondent, is directed to give an opportunity of hearing to the petitioner, and the private respondent or their authorized representatives, and to dispose of the issue raised in the order dated 15th of April 2025 by passing a reasoned order as expeditiously as possible within a period of, Mr. Chakraborty?
My lord, may grant 4 weeks, my lord.
4 weeks, not heavy. Raise it
4 weeks, Mr. Chakraborty. Deciding this plan, whether there is, I think, 2 weeks will be sufficient.
My lord.
Period of 2 weeks from the date of hearing fixed by this court. So it is, however, made clear that since the date and time of hearing has been fixed by the court in the presence of the learned advocates for the respective parties, there would be no necessity to issue any further notice upon the private parties.
I'm grateful.
My lord, most good.
Observations and directions, writ petition number such and such stands disposed of. আচ্ছা, একদম উপরে দেবেন this matter was mentioned today at the first sitting of the court by Mr. Jaipal, citing great urgency. Considering the urgency pleaded by Mr. Jaipal, this matter was directed to appear in the supplementary list today. Accordingly, the matter is appearing in the supplementary list, and Mr. Jaipal has intimated the time of hearing of this writ petition upon the learned advocates for the respective parties. এটা একদম উপরে।
My lord, most good.
কোনটা ওটা একটু What is the urgency?
The urgency is that yesterday I came to know that the judgment debtor is liquidating his property, my lord. If he succeeds, my lord, I will live with no remedy, my lord. My lord, I have applied in 30 of April, my lord. Today the department has said, I have inquired with the department. Today that the Xerox machine is not working, my lord, and until and unless it is already.
You have the server copy.
I have the server copy, my lord. Department is not accepting it. I'm praying for leave.
Yes, call the list.
My lord, in the monthly list, my serial number 65, already 64 had been done. But the next matter, the 65, is not mentioned in the today's list. 65.
65, it will be taken up. Monthly list will be taken up. Please keep a watch on the list. It will be indicated.
Today it will not happen.
Yes, call the list.
Item number 301, 302.
Any other day. Because I've been
strategy is difficult.
Lordship, I am for the petitioner led by counsel, senior counsel Surajit Nath Mitra.
I am
on your
Praying for short pass.
after considering your convenience, this date was fixed.
Now there is a different problem in our side, and which I can't say in open court. There is a problem here, my lord. Who is going to argue that will change? So now
arguing counsel has changed
because he's in difficulty, my lord. So we will have to do the matter.
Mr. Chatterjee, you are ready. We are all along there.
My problem is, my lord, I am addressing, my lord, a continuing part heard before Justice Ajay Mukherjee. I have taken 4 adjournments and I have given his lordship word that I will finish today. I just,
Mr. Chatterjee, it's not possible for me to fix another date before the vacation.
Keeps it after the vacation.
Please bring the other side. I do not know. I can only make it.
The next date is 4th of June. 4th of
Chatterjee, the only difficulty is that I will forget. The hotly contested matter. Other side has concluded the argument.
I will your lordship.
That will be only wastage of time, Mr. Chatterjee. That is why I wanted it.
Practical difficulty.
Had to be on the previous week. But since you have said on your prayer, it has been fixed today.
My practical.
You are all along there from the
my
very
practical difficulty. Kindly appreciates my problem.
Mr. Mukherjee is also there.
My problem.
No, yes, Mr. Mukherjee is leading you also.
Who, Mr. Mukherjee?
Other Mr. Mukherjee.
But the Mukherjees are afraid of the Bhattacharjis, it seems.
Chatterjee, it's only that is the difficulty.
Considering that, my lord, ultimately, Lordship fix the matter today, my lord. They prayed
on Tuesday at 3 o'clock.
Cannot.
Then we will. Then, my lord, kindly grant some protection to us, my lord.
Has to be.
Kindly grant some protection. In the trial court, they are extending the entry order by filing application, and we have to challenge all the orders before your lordship court.
The 4th of June is the next day. Any day, your lordship pleases.
Where is the next date prior to 4th of June? We are reopening on when?
9th June.
So,
again extension.
Mr. Chatterjee, do you know till which time this court functioned in the first before recess?
1:30.
No, even after that. But only for this, and pursuant to the request that these fixed matters are not being taken up, I was fixing at 3 p.m., 3:30 on your request from the bar. Today I fixed it. Only 7 or 8 days left prior to the vacation.
Kindly appreciates my problem. I could not have troubled you.
Lordship put the matter after some time, then kindly put some interim order. Kindly grant, my lord. Mr. Mitra argued 2 days, my lord.
Any day, your lordship. Just my practical difficulty, I don't trouble your lordship. Here, there is a practical difficulty which has arisen today in the afternoon. Otherwise, Lord, I would not have come and prayed for.
Would have taken up today after 3:30. I think you would not be having difficulty, but there's a difficulty for the court because I have heard a matter. I have to deliver a judgment, so I have fixed the time at 4 p.m.
Port Blair.
No, not Port Blair. Mr. Rai was arguing. So it has to be because 11th, yes, Mr. Parthavi, 11th, something is going to happen. So I have to pass an order. I have tentatively fixed 4 p.m. It might be something. So after that 3:30, I have to, or even I could have taken up at 3:30
on
also.
Tuesday 3:30, next Thursday 3:30.
No, I am making it not today on your prayer.
No, ma, then kindly substitute some. No, ma, then we will opposing, my lord. Madam, kindly, kindly
Strategy,
put
then
some interim.
They are
Some
opposing.
interim order.
They are opposing. You have to start. You have many councils here.
Makes it not today means tomorrow.
So, Chatterjee, you are not the only council appearing in this matter.
Chinese
There are others also.
Nobody.
That is for you.
There is nobody.
Mr. Probal Mukherjee, Mr. S.N. Mukherjee, diary was
I
congested.
can do one thing. If you want, I can take it up at 3 p.m. I can take it up at 3 p.m. That much I can do. Because fixing another date for these matters might be a difficult prior to vacation. If you want, because motions are to be taken up, if all of you want fixed matters, I have no difficulties in taking.
Next week at any time at 3.
Speak with strategy is not possible.
Friday at 3. Next Friday at 3.
I do not know what will happen next Friday.
My lord keeps it there at 3 o'clock. Then if not, your lordship does whatever your lordship. Just one day today, there's a difficulty. Otherwise, I would not have. I'm not shying away from doing the one.
So Chatterjee, is not that. I'm not telling that you are shying away. But it's the difficulty because these matters I have heard. I think
and
Mr.
in that matter,
Mitra has argued for 2 or 3 days.
In that matter, Mr. Surajit Mitra is for the other side and he is going to go and say that why aren't you doing it 5 days? Tenant. I was not in Calcutta, I was outside. Mr. Rai and Mr. Mitra are opposing them a lot. I'm just safe because his lordship sits about 5 minutes, 10 minutes late. Just today's, and whenever your lordship, please, I give your lordship what I will do it. Whichever Mukherjee comes, doesn't come, I will do it.
Fine. Mr. Chatterjee, Lanet, yes. Call the next matter.
So 3.
Your Lordship, I'm appearing for the petitioner. I am praying for an accommodation on a personal ground. I am led by Mr. Siddharth Banerjee, Your Lordship. He had come to court this morning, but suddenly he fell sick and had to rush home. Kindly, if Your Lordship keeps it.
Strategy.
No, there are 2 senior advocates in this matter.
Mr. Chatterjee, look at the predicament. You requested, you mentioned.
The problem is this.
This fixed matters at 2 p.m.
Now, the problem is this.
10 days are also not left before the vacation.
No. That I know. Your Lordship, kindly see your Lordship's order. Your Lordship's order. On.
Lordship, he had come.
No.
But he had to rush home because he felt sick.
Rush home, everything. But my clients are suffering. 4.5 crores rupees are due and payable. Admittedly, they have taken
Where is Mr. Basu?
I don't have instructions.
I am strongly opposing this.
Yes, ask him. Yes, where is
Tomorrow you will mention for extension of interim order.
Engaged before another court, I'm told, Your Lordship. He's engaged before another court at this moment. Is what I'm told.
Ask him to come. I will, for the timing, I will hear Mr. Chatterjee. Ask Mr. Basu to come. Yes.
Come to the order impugned.
Or if you want to make submissions, you can make.
No, Your Lordship.
If you want to make submissions, if you want to start, you can start. Or else Mr. Chatterjee will make his submissions. It's
My
your
learned
choice.
senior friend may
Because
continue.
you have a first right, you can make your.
Let him make his submission.
If you want to make submissions, you can start. Please start.
My learned senior friend may continue. So Mr. Shoptangshu Basu may be coming.
Mr. Basu is coming. Please start, sir.
I don't.
Please start.
You have your brief or you
No,
don't
Your
have the brief.
No,
Don't have the brief.
Judgment of order.
Yes.
But
Take the.
I am giving my brief.
Yes.
Order, judgment of order.
When have you been enrolled?
2023.
2023. So
Yes.
2 years. Now you can start. Yes. Please start.
Your name ki baba?
Mr. Chatterjee, please tell where is the impugned order. Please tell him.
Yes.
Please show it to him.
এখান থেকে শুরু। তোমার নাম কি? অঞ্জন ভারতী।
I'm
It's
not,
in which volume, Mr. Chatterjee? Impugned order is
First volume.
first volume. Which page?
Well, it is 0 page. It start from the first beginning. Beginning. After the cost title and other thing.
Oh, after the cost title, why the certified copy has.
No, your Lord, no, not certified. From the beginning itself.
All right.
From the beginning. First, second, third page. Practically number 3 page.
All right. Yes. Yes. Yes.
I'm not briefed in the matter, Your Lordship. I don't have instructions also. Your Lordship will kindly pass
Right. Then
one
Mr. Chatterjee
accommodation.
will start. Yes, Mr. Chatterjee, please.
Bless Your Lordship.
Normally, your Lordship kindly come to the order impugned first.
Yes.
The instant appeal is preferred against the order dated 16/1/2024 passed by learned DRT 3 Kolkata in SA number 229 of 2023 MS only Wheel versus Bank of Baroda, restraining the appellant bank from taking any coercive step in respect of the secured properties on the basis of the orders dated 6/10/2023 and 28/11/2023 passed by the learned district magistrate, not 24 Parganas. But these are the 2 orders passed on section 14 of the Sarfaesi Act regarding police help. As per the pleadings of the parties, the facts of this matter are that the predecessor interest of the respondent Sri Shailendranath Ghosh availed overdraft facilities of 300 lakhs from the appellant bank, which was not repaid. Accordingly, proceedings under Sarfaesi Act 2002 were initiated by the bank. Notice under section 13(2) and 13(4) of the Act as required under the Act was issued. Proposal for one-time settlement was also made, which could not be fructified. Representation made by the respondents were duly considered and replied by the appellant. Thereafter, an application under section 14 of the Act was moved by the appellant before the district magistrate, South 24 Parganas. District magistrate passed the order on 6/10/2023 under section 14 of the Act, directing the inspector in charge Tiljala police station for necessary action. Previously, the mortgage property was lying within the Tiljala police station, which is now under Pragati Maidan Police Station. Accordingly, an application for acting upon the order dated 6/10/2023 was made by the appellant before the district magistrate, which was allowed by the order dated 28/11/2023. The learned district magistrate passed an order directing the inspector in charge Pragati Moidan for necessary action. A Sarfaesi application being SA number 229 of 2023 was filed under section 17 of the Act by the respondents, challenging the action of the respondents with an interim application for staying and quashing the order dated 28/11/2023 passed by the District Magistrate South 24 Parganas, done a DRT-wide order dated 16/1/2024, passed an interim order restraining the bank from proceeding further in compliance with the order dated 6/10/2023 and 28/11/2023 passed by the District Magistrate. Feeling aggrieved by the impugned order, appellants prefer the instant appeal. I have heard the learned counsel for the parties at length. Learned counsel for the appellant to submit that the impugned order passed by the learned DRT is against the law. It is submitted that initially an order under section 14 of the Act was passed by the learned district magistrate on 6/10/2023. Since the name of the police station Tirijala was to be replaced by the police station Pragati Moidan and the name of the officer authorized to take possession, Srimati Moha Bandopadhyay, WBSAC Executive, South 24 Parganas, was to be replaced by Srimati Renuka Roy, WBAC Executive, South 24 Parganas. Order dated 28 November 2023 was passed. It is submitted by the learned counsel for the appellant that district magistrate was well within his powers to pass the impugned order. The learned district magistrate was acting under the provisions of section 14 of the Act for nominating another person for taking physical possession as earlier officer appointed has been transferred. It is further submitted there is no requirement of filing another supplementary affidavit before the district magistrate for issuance of an order under section 14 of the Act, as already an affidavit was filed by the secured creditor. It is further submitted that the learned district magistrate is just to assist the secured creditor in taking physical possession of the secured assets. He cannot be an adjudicating authority, rather he is simply carrying out a ministerial work. It is further submitted that the learned district magistrate for an impugned order is concerned, as far as impugned order is concerned, was not functus officio, as the name of the officer was authorized to take possession and the name of the police station was substituted as earlier order officer was transferred. It is submitted that this is simply a mechanical work which did not require any exercise of the judicial mind. The district magistrate has the power to pass incidental order to implement its order passed under section 14 of the Act. It is further submitted that the powers under section 14 of the Act are simply executory in nature. Per contrary, learned counsel for the respondent would submit that provisions of section 14(1) of the Act empowers district magistrate to take physical possession of the secured assets. Under the unamended provisions of the district provisions, the district magistrate has only to issue a memo and himself proceed to take the physical possession of the property. There is no requirement of passing any order in the pre-amended provisions of section 14 of the Act. It was argued by the learned counsel for the respondent that the first time after the amendment of section 14(1) of the Act, a proviso is added requiring the secured creditor to file an affidavit of 9 points, then the district magistrate was required to satisfy himself about the factual veracity of the affidavit. It is submitted by the learned counsel for the respondent that there was no amendment made under section 14(2) of the Act. Section 14(2) of the Act does not include the word order. It pre or post amendment scenario. Hence, district magistrate has no power to pass a fresh order by way of modification or alteration in the order, give an effect of in the earlier order already passed. He become functus officio as soon as the orders under section 14 of the Act as passed by him. It is further submitted that district magistrate has no power to pass fresh order in terms of section 14(1) of the Act unless and until statute provides the same. It is further submitted that section 14(2) of the Act is independent of section 14(1) of the Act. Hence, section 14(2) of the Act in no way authorizes district magistrate to pass any fresh order or to modify its earlier order. Reliance is also placed non seeker solis. It is submitted that there is no there are submitted that when there are doubtful words, the meaning of a doubtful word may be ascertained by reference to the meaning of the word ascertained with it. Accordingly, the word step issued shall be interpreted in a manner that it does not empower the district magistrate to pass fresh order under section 14 of the Act. We have to see whether the district magistrate, by passing the impugned order, has exercised its power under section 14 of the Act, whether he becomes functus officio and has no power to substitute the name of the officer appointed to take possession of the police station. This was the issue fixed by the learned DRAT. Now, thereafter, the section 14 has been quoted. I am skipping over the same. After the order passed by the district magistrate on 6/10/2023 is this.
Yes.
না রে বাবা, এই 6-10 অর্ডারটা এটা অ্যানেক্সার করেছে কোথায়? Your Lordship, kindly see the order impugned, order 6/10/2023 has indicated that the Yes. Your Lordship, kindly come to page 9, last paragraph. Due to administrative works, this possession order could not be issued within the stipulated time period for the date application to this office, and after careful consideration of the contents of the affidavit, including 9 clause mentioned under section 14(1)(b) of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, all other relevant documents which the secured creditor filed duly affirmed by the authorized officer Vishnu Tower such and such are being satisfied is hereby ordered as per amended section 14(1)(a) of the Sarfaesi Act 2002. Srimati Mohuha Bandyopadhyay, WBC Executive, is hereby authorized to possession such assets and documents relating thereto and to forward such assets and documents to the secured creditor with police assistance. Whereas the authorized officer Indian Bank will initiate the date of possession of the secured assets to the Commissioner of Police as Kolkata, as well as to the authorized officer Srimati Mohuha Bandyopadhyay, WBC, well in advance to take physical possession of the secured assets, property of the secured creditor on behalf of the District Magistrate South 24 Parganas, and the Commissioner of Police will instruct local police station give police assistance for maintenance of law and order as when approved upon the secured creditor will remain present at the time of taking physical possession. Photostat copy of the order may be available, etc. Now, when this order was passed, at that time, it was of the impression that the police station is Kosba, Tirjola. That has been indicated in the schedule of the property. Your Lordship, kindly come to page 8.
Page 8. Yes.
Your Lordship, kindly see schedule of property, equitable mortgage. Tirjola.
Yes, Jadavpur, Old Taliganj, New Pragati Maidan.
All the three, but now the Tirjola police station, it was there.
Yes.
Tirjola, PS Jadavpur, Taliganj, New Pragati Maidan. New Pragati Maidan, Old Taliganj, New Pragati Maidan. Alipur under jail number such and such. Now, this was the difficulty we are facing for implementation of the order, because Mohuha Bandyopadhyay has been since then transferred on 6/10/2023, and the police station Tirjola has become Pragati Maidan. So, for correcting the order, one affidavit has been filed. For implementation of the order, affidavit has been filed. And in the affidavit, on perusing the said affidavit, the district magistrate passed an order on 28/11/2023. Now, the affidavit we have filed কত নম্বর ভলিউম এটা?
Volume number 2, sir. Volume number 2 is number 297.
Your Lordship, kindly come to volume number 2, page 297. There, the affidavit representation has been annexed. Volume number 2, 3.
Sir, it's not.
No.
Page 297.
297, my lord.
Volume number 2 করতে হবে। Volume number 2, yes. Your Lordship, kindly see page 297.
Yes. No, this is not an affidavit.
This is simply one application.
Yes, only one letter.
Letter. An earlier page, the order of the order dated 6th October 2023. This is the order. And you will also kindly see in that volume 2, page 296.
Yes.
Why we are facing difficulty because of this? 296, last paragraph.
Yes, that is the order which you have placed just now.
No, that is thereafter. Copy forwarded for information and necessary action to Commissioner of Police, Moha Bandyopadhyay, Inspector in charge or Officer in charge, Tiljala Police Station.
Yes.
That is the difficulty. At that stage, Tiljala Police Station is not there. He has instructed, instructed Tiljala Police Station to take necessary action. But Tiljala Police Station was unable to perform this duty. They have informed us. Accordingly,
because the police station has been changed. Police station has been changed.
Pragati Maidan has come. Well, the various Calcutta police station have already been changed. Your Lordship knows, Kasba police station has been bifurcated by 3 police stations. This Pragati Maidan, one is, my police station is, I forget the name always. OC regularly, no. OC regularly called me. I used to forget the name of the, that is, whatever it is.
Yes.
There another police and Kasba police station. There are 3 police stations. Just like the motor vehicles offices. Only one PVD was there for entire South Calcutta. Now PVD
has come up.
Not only Kasba, Behala has also come.
Yes.
Alipur, Behala, Kasba, and this Beltola. All are there. So, this was the difficulties we are facing. That's why this letter was sent to the district magistrate. This was the letter.
Yes.
It will be written Pragati Maidan and instead of this. And in the meantime, the officer, Mohua Bhattacharjee, has been transferred. This is incidence of service. She has been transferred from this place to another place. He's a WBCS officer. It's gone. Another officer has.
So actually, it's the post which matters, not the name of the person.
Yes.
It's the post which matters, not the incumbent.
Yes. Post in which the matter. Now, here the name of the post, the person holding, that has been given. That has to be changed because he is not there. Who will take possession of the property? The person concerned is not there. And the police station, give the police assistance, that is not there. This is the only continuation made in the order of 2610. That
the order of 28th of November.
My lord, I am placing. In the volume, in the volume 298. In the
yes,
volume
298. Yes, I've got that. Page.
Same order.
Well, within these 3 volumes of civil division applications,
that is the department is that when my learned junior has briefed me all these copies, I say now civil division of this voluminous. Well, now this is the thing they have filed. When I put my signature, then all these things were not there. That was 30 years back.
You have put signature long back. I also did not get this. Not at the time of putting the signature. Also, prior to elevation, I did not get this. 3 volumes, 4 volumes of civil
No, no, no.
petition application.
No, I have not seen. Now, my lord, they,
I think it's after the online process, after the COVID, I think these 2, 3, 4 volumes are coming. Not prior to that.
all these things have been made by the honorable judges, one after another. Now, today I have heard that for doing affidavit, the telephone number of the client has to be given. If the client has no telephone, petitioner has no telephone.
Now, Mr. Chatterjee, only these things are happening because there is a dispute with regard to the identification. Previously, it was not there.
No,
now fake affidavits are being.
Yes, department is sending the message to the particular person that your matter is on that date.
For that purpose, it is required. So nowadays, what you are telling that if the client does not have the telephone number, now most of the persons have telephone numbers.
Everything
even
now,
for the purpose of operating the bank accounts, you must
yes,
be having.
yes, everybody.
Now, phone number is available.
That's why the India is most valuable country in the world. 140 crores people having so much of purchasing power. Nobody is dare to touch India. That is the whole trouble.
Yes.
Now, page 298, the schedule of property.
So, yes.
Schedule of property is the only change, Pragati Maidan. Previously known
So
as
now Pragati Maidan has been changed and the name of that person has also been changed.
Yes.
Which page?
Page 300. No. এখানে এই মহুয়া বন্দ্যোপাধ্যায় yes, page 300 and second last paragraph. Renuka Roy.
Yes.
Renu Roy.
Yes, I've got.
And now you will also can see information necessary action. Runu Roy, Inspector in charge, Pragati Maidan.
Yes. So these are the 2 changes in that order.
No fresh order, no new order, nothing. Now, yes. If your lordship kindly have a glance to section 14 of the Sarfaesi Act, 14.1 and 14.2.
Yes.
Your lordship kindly see 14.1 A, the application is to be filed.
14.1, yes.
The application is to be filed, the authorized officer by the authorized officer. These are the things to be given.
Yes.
These are things to be given.
Yes.
Now you will also kindly see, now when the order district magistrate 1A, the district magistrate and the chief metropolitan magistrate may authorize any officer subordinate to him to take possession of such assets and documents relating thereto and to forward such assets and documents to the secured officer. Now, 14.2. For the purpose of securing compliance with the provisions of subsection 1, the chief metropolitan magistrate or the district magistrate may take or cause to be taken such steps and use or cause to be used such force as may in his opinion be necessary.
Yes.
So, my lord, here what he has done for securing compliance of the order 14.1.
Yes.
That is within his power. That cannot be said to a functus officio. And that is the whole gamut of the argument before the learned DRAT and also in this revisional application. Now Mr. Basu has come.
Strategy, you can conclude thereafter, Mr. Basu.
Yes, I come.
Strategy will not take much time.
No, I have had a talk. Till I arrive, he will continue.
No, not at all. I have another matter before.
Gentleman's agreement. I just coming.
Yes.
So This has been answered by the presiding officer DRAT on learned judge from page 10, paragraph 17. Only thing I will wait for Mr. Basu, that if he places certain decisions, that I shall distinguish. Otherwise, in respect to the facts and the point of law, I shall conclude today.
Yes.
Paragraph 17. Whole controversy arises on this count as to whether the district magistrate was empowered to change the name of the officer in the police station. Whether the district magistrate become functus officio even where only the name of the officer is changed, where the district magistrate was required to pass an order under the unamended provisions of section 14 of the Act, whether, not where, whether the district magistrate was required to pass an order under unamended provisions of section 14 of the Act, whether a fresh 9-point affidavit is required under the proviso of section 14 of the Act should have been filed by the secured creditor. Now, my lord, certain decisions have been এখানে তো ডিভিশন বলা আছে না, মানে the learned judge has relied upon certain decisions. Our first decision is relied upon. May I place this decision?
Yes, yes.
First decision is
relied upon by you or them.
Well, these certain decisions are relied by me. Certain decisions relied
You
by
can
them.
place that. So, what they have placed, you can distinguish that. And whatever.
My decisions are here. 3 or 4 decisions of mine. আমাদের কোন ডিসিশন গুলো ছিল? You also can give 1 minute. আমাদের রিটেন নোটসে রয়েছে, কালকে বার করা হলো না? কোনগুলো আমরা দেখিয়েছি? We have shown the decisions. দেখো এখানে রিটেন নোটস অফ আর্গুমেন্ট আছে। Martiminal লাইনই তো।
Yes, sir. Applicable on data.
Yes, your lordship, we have relied upon the judgment as paragraph 27 and 28.
Please give me the citations, your citations.
First is Taira versus Federal Bank, 2016 SCC online, Kerala. 2061, I am giving this.
This is your decisions only.
Yes, these are my decisions.
Yes.
Tahira versus Federal Bank, 2006. This is in that book, 56 to 57. আমাদের কপিটা এখানেই ছিল তো, এই তো এখানেই আছে না, কোথায় গেল?
Yes.
Next is Misri Bai. This is in serial number 5, 49 to 55.
Yes.
And Maruti Minerals. This is 40 to 48.
22 SCC online.
And this is the
after Misri Bai, then Maruti Minerals.
Maruti Minerals. আমাদের কলকাতা হাইকোর্টের একটা জাজমেন্ট ছিল না প্রসেসিং ভট্টাচার্য?
Mr. Chatterjee, there is no Calcutta judgment.
Calcutta judgment is there. That is
32 to 39.
State Bank of I have given, that is
State Bank of India
versus State of West Bengal and others.
WPA
6,000, 8,000 of 2020 decided on 13th February 2024 by Honorable Justice Sarfaesi Act.
Yes.
Dear Lordship, can you see page 32 to 39?
Yes. So this is on that issue that
yes,
it does not become functus officio.
Yes, your Lordship, can you see learned page 33?
Yes.
Yes, page 32 itself.
Yes.
Yes. Learned Counsel contains the CMM acted without jurisdiction since he has rendered functus officio after having passed the order dated September 21, 2021, directing any padlock to be broken for giving physical possession to the bank, which again in pursuance to an order dated December 12, 2024, passed under Section 14(1) of the Sarfaesi Act. Learned Counsel for the bank submits that the purpose of implementation of an order passed under Section 14(1) and subsection 2 of the said section empowers the magistrate to pass necessary order within his contemplation, of which the order dated September 21, 2021 was passed. However, it is argued that the order restraining the bank from taking possession of the premises on the basis of the allegation of the previous private respondent that the latter was a pre-existing tenant was beyond the domain of the magistrate to decide. If any cause of action in that regard was to be raised, the same has to be done under Section 17 of the Sarfaesi Act before the concerned tribunal. The Learned Counsel for the CMM submits that for the purpose of implementation of an application under Section 14, deciding this same, the CM has ample jurisdiction to ascertain whether affidavit filed before in support of the application disclose the correct facts. In the present case, since the bank suppressed the existence of pre-existing tenant, it is submitted that CMM has within its jurisdiction in passing the impugned order. That apart, the argued that the same logic by which the CMM was functus officio after passing initial order, the bank also could not have obtained an order for further breaking open the padlock as done by the bank on September 21, 2021. Learned Counsel for the private respondent submit the writ petition need not be entertained in view of availability of equitable.
So Chatterjee, answer is in paragraph 21 and 22.
Yes. Section 14(2) undoubtedly refers back to Section 14(1), provides that for the purpose of securing compliance with the provisions of subsection 1, CMM may take or cause to be taken such steps or use cause to be used such force as may be his opinion necessary. The order passed in the year 2014 was under Section 14(1), whereas the order passed on September 2021 was in furtherance of the same, in order to implement the same effectively within the completion of subsection 2 of Section 14.
Next, paragraph 23. It's the conclusion.
Hence, it cannot be said the CMA was functus officio at the juncture of passing the order dated September 21, 2021. The same thing has been iterated in Misri Bai, Tahira, everywhere. And your Lordship can see this is the latest judgment of Gujarat High Court. Take page, it is from page 58 to 72. Authorized Officer, Bank of Maharashtra.
58 to 72.
Yes.
Yes.
Your Lordship, can you see? The Article 2, then your Lordship, can you see? Yes. Page 60, paragraph 2.6. Petitioner bank approached respondent number 1 under Section 14 of the Sarfaesi Act by criminal miscellaneous application number 8064 of 2022, stating all the aforesaid facts and seeking repossession of the property in question, which very well. My learned junior is asking me to place this paragraph 2.4, just earlier paragraph. The court commissioner took over physical possession of the property in question on 6/3/2022 and handed over the same to petitioner bank. The said court commissioner has also drawn necessary panchnama and take photograph of the property in question during the course of taking physical possession. The court commissioner has also submitted his report in this regard to respondent number 1 by letter dated 14/3/2022. 2.5. The officer of the bank visited the subjected property on 8/3/2022. It was found that the respondent number 2 has broke open the locks applied by the court commissioner and illegally trespassed into the property in question. Hence, the petitioner bank immediately lodged a police complaint in this regard on 9/3/2022 before the police station, which is still pending for investigation. The petitioner bank approached the respondent number 1 under Section 14 by criminal miscellaneous application number 8064 of 2022, stating all the aforesaid facts and seeking for repossession of the property in question, which came to be rejected by neutral citation such and such, identified with the impugned order dated 21/2023, being agreed and dissatisfied with the order dated 21/2023 by the respondent number 1, petitioner has preferred the present application under Article 226 of Constitution, has prayed for the following. Now, your lordship, kindly come to page 71. All the decisions have been relied upon, then page 71. এই যে জাজমেন্ট আমাদের এই বইটা ওকে দিয়েছো কি? এই যে জাজমেন্ট দেখাচ্ছি আমি, রেফারেন্সটা বললাম তো, বলিনি? বলে দাও। Paragraph 70, page 71, paragraph 12.1. In the facts of the present case, the order passed by the learned district magistrate dated 1/2/2022 under section 14 of the Act in criminal miscellaneous application number 4360/2021 is valid in the eye of law, as also until the dues of the secured creditor has not fully satisfied with the sale proceeds. The borrower as well as the guarantor shall not be discharged from liability to repay the loan amount to the bank unless the bank recovers the entire outstanding amount from the borrower guarantor of the secured assets.
Paragraph 12, last two lines. Next
line.
page 72.
Yes. So my submission before Lord.
This is the logic.
This is the logic.
Anything more, Mr. Chatterjee?
One thing. দাঁড়াও Maruti Minerals Joseph দেখিনি। Now, may I place the Maruti Minerals also?
If you want, you can place.
Your lordship, can you see Maruti Minerals? That is page 40.
Yes.
Your lordship, straightway kindly come to, this is the judgment delivered by Justice Joymallo Bakshi while sitting in Andhra Pradesh.
ক্যালকাটা জাজমেন্ট হলো না, অন্ধ্রপ্রদেশেরই হলো।
আমি ক্যালকাটা জাজমেন্ট দেখিয়েছি একটু, সবুজ ভট্টাচার্য। Yes, your lordship, kindly come to page 46, paragraph 21.
Yes, I'm at paragraph 21.
While disposing with an application under section 14 of the 2002 Act, the magistrate is not disposing of a case under the code. Moreover, there is nothing in the 2002 Act which provides an application under section 14 to be dealt with under provisions of the Code of Criminal Procedure 1973. Hence, we are of the opinion that the aforesaid bar does not restrict the powers of the magistrate while exercising the powers under section 14 of the 2002 Act. In the present case, magistrate exercised the power to reopen the case to permit the Advocate Commissioner to perform a ministerial act, namely submission of the report relating to the recovery of the possession. Receipt of the report by the magistrate was purely an administrative and executive function, and in doing so, magistrate did not exercise judicial function or adjudication of interstate rights in respect of the subject matters of the secured asset or the nature of transaction. Any dispute with regard thereto was remediable before the tribunal or by invocation of the power of the judicial review under Article 226 of the Constitution of India. Judged from this perspective, the action of the magistrate in accepting...
Paragraph 24, last three lines.
Yes, yes.
Hence we hold.
Hence we hold that there was no error of law on the part of the magistrate to permit the ministerial act. Here the case was that the...
Notwithstanding earlier order of closing the proceedings.
Yes.
Anything more, Mr. Chatterjee?
Number only thing. Kon Supreme Court? এখানে প্যারাগ্রাফটা বলো।
25, 26, 28.
Your Lordship also kindly see R.D. Jain and Company versus Capital First Limited page. It is from page 1 to page 18. Your Lordship straight away kindly come to paragraph. Yes. Your Lordship kindly see the head note C also.
So this is Mr. Chatterjee on a proposition that whether additional chief metropolitan magistrate, additional district magistrate can exercise. That is a.
So now the only thing what I intend to submit, that the reasons given by the learned trial judge from paragraph 17 to rest as to why this is not functus officio and the why as to why this is not a fresh order.
Let me hear, Mr. Basu. Anything more you want to submit? You want to submit anything more?
No, only thing that in the revisional application, they did not take a single point on this.
On what?
On this, why it is functus officio and it is not, it is functus officio.
What is the challenge in this revision application? What did it, what point did it take?
He said, your Lordship, can you see the order of Honorable Justice Raja Basu Chaudhary? 19-12 orderটা দাও এক্ষুনি বার করে দিলাম 19-11 your Lordship, can you see?
Order dated
19/11/2024.
Yes, 1911.
Paragraph 2. Paragraph 2. It appears that primary ground for challenge in the present divisional application is with regard to the scope, authority and jurisdiction of the district magistrate to pass an order on the above nature after having previously exercised jurisdiction under.
Yes, functus officio is under challenge.
Yes.
He has said that that is the point noted.
That is the point.
That since he has disposed of, then he has become functus. That is the challenge.
But in the revisional application, nothing has been said why these judgments.
The grounds, Mr. Chatterjee, do prepare yourself in a civil revision application looking at the grounds. I don't think Mr. Basu does so.
I also. No.
You look at the grounds of the civil revision application.
Now at this stage, I believe Mr. Basu also did not put any draft, only signature. Settled.
Mr. Basu has settled this.
Definitely.
That, my lord, if you look to the petition, my lord will understand whether I have settled it or not. That much I am sure.
In any way.
Anything more?
Let Mr. Basu, if he adds anything apart from my submission, then I shall indicate. Otherwise, not.
Yes, Mr. Basu.
The size denotes that it is not from civil seriousness of this petition.
Why are you allowing this, Mr. Basu?
I don't know. Nowadays, should I submit? What is our revisional application? Including affidavit, 10 pages. Now, if you don't annex everything, judge will scold you. Why have you not annexed this? Petition, plain, written statement, evidence, whatever you want to show, you have to annex it.
Mr. Basu, in some cases, in some matters, portion of that evidence is necessary.
In our days, younger days,
it could have been. It could have been placed, that is one way.
My lords are insisting, you have to do it. Divisional court, if says, what the junior will do. They are annexing everything.
I have not insisted. I am taking copies from there.
That is the orthodox civil practice.
So, not that, but
yes. How dare I to say somebody that don't annex? If go to such a court, he will be getting scolding from that court who have not annexed this.
Yes, please come to the matter.
227 petition. So whatever ground I have challenged, the taken or not taken, my lord, all grounds available to me, I can on the basis of admitted fact. But kindly come to 14. Section 14.
Section 14, yes.
No, trouble or not, can you turn? What the magistrate should be dissatisfied himself? Those are Roman 4, Roman 5. Can you turn? After proviso, provided that any application by the secretary shall be accompanied by an affidavit duly affirmed by the authority.
9-point affidavit.
What are those? Can you read 4, Roman 4? The borrower has committed default in repayment of the financial assistance granted exceeding the specification amount, and consequent upon such default in repayment of the financial assistance, the account of the borrower has been classified as a non-performing asset. I am closing them. So NPA is a sine qua non to exercise jurisdiction by the magistrate. He has to satisfy himself.
Mr. Basu, show me that point was raised before the appellate tribunal.
I say on admitted fact in 227 court.
Please show me that point was raised.
Taken. Even if not taken, can I not take on the admitted fact? Well, your lordship can recall to 1960 the Supreme Court Constitution bench. On the admitted fact, with the Supreme Court, I can take this point for the first time. But still in his lordship mind, I can take this point on the admitted fact. I will not add any fact. Now, my lord, first NPA was on 29 June 2018. Can you come to page 45?
So, Mr. Basu, I will take it that you do not have any point in functus officio.
No, I have.
So, you can proceed with that, then take me to,
yes.
Because that was the issue which was decided. Please show me that.
Please go to the root of the matter. How the
Mr. Basu accepted, but if it was going to the root of the matter, what prevented you from taking that point before the appellate tribunal?
I will come to that. I will come to that.
Before the tribunal, before the appellate tribunal.
Section 17 is pending. I am coming to that.
Take that point.
I am coming to
if whatever is available.
In the meantime, my property will go. Supreme Court says that if the order is under challenge, the appellate court should stay the order, operation of the order. I will come to that. Well, kindly come to page 45.
Page 45.
45.
When you are referring to the pages, please tell the volume.
No,
Refer to the volume also.
First volume. 45 will be in the first volume. So this volume is creator is Justice Sampa Sarkar. If he has sustained an injury in his hand, so this volume he could not carry. So it's a volume.
One volume is very difficult, Mr. Basu.
Not
For me, I can.
Everybody.
One volume is difficult for me. Yes.
So kindly come.
Yes.
Paragraph C. As you are aware, you have committed default in payment of interest on the above loans outstanding of such and such. Consequent of the defaults committed by you, your loan account has been classified as non-performing asset on 29 June 2018.
Mr. Basu, that is an issue in section 17.
I will come.
So if don't, how can I enter into these facts here?
Not what I will submit, my lord. If an issue is on the face of it, 227 court, had it been 150, I could not say this. Then, my lord, whether your lordship will allow to execute the decree, I am putting on charge. Only using of decrees as a civil code I am using. If today I am dispossessed from my property and ultimately it is decided the NPA is wrong.
Where is the order of the tribunal?
That
Which was subject matter of challenge before the appellate tribunal?
Kindly come to 274, second volume. Before that also I want to show something for my. 16 January 2024.
So this was challenged before the appellate tribunal.
I'm coming to that, one after another. So kindly, as the Malord is 274, kindly come to last paragraph of that. It is stated that the date of classification of the account of the application as NPA is done in violation of the decision of the Honorable Supreme Court. It is such and such and such. Then, my lord, decision with reason. Controversy originates as the London District Magistrate had passed two orders, one dated 6 January 2023 and another dated such and such. The order dated 28 November 2023 specifically records that this order issued in continuation of an earlier order dated such and such. It appears that both the orders are in operational mode. Under the present circumstances, both the orders simultaneously cannot survive. It is not apparent from the order dated 20th November 2023 that the order dated 6th October 2023 is modified to the extent of change of police station and change of name of the executive officer. So both the orders simultaneously exist. The impugned order dated such and such is in continuation with the order dated such and such with necessary corrections, modification and substitution thereof. Well, kindly pause there for a moment. I am reminding your lordship whenever there is a mistake. This is the normally your lordship is to do, that it is modified to that extent. But here there lordship will not find. Whenever there is a mistake, we point out to the court alter it, and in our days, the certificate copy already handed over to be returned to the court.
For correction.
No, corrected. Your lordship has corrected. So in the meantime, I obtained a certificate copy.
Yes.
Had to return this to the court.
Yes.
There is no existence of two orders.
Yes.
Now, my lord, the court, this tribunal is finding that the nature of the order passed, both the order, is both are coexisting. Which is to be executed? Am I clear to my lord? Can you see the two orders are there?
That is the dispute. So let me clarify which is to be executed.
This is one point. So the nature of the order, your lordship will find only it has been changed. It has not said that the earlier order has been modified to that extent. Not done. Then kindly proceed. Under the present circumstances, both the orders simultaneously. It is a settled principle of law that once the order is passed by the London District Magistrate, the application under Section 14, it attains its finality and there is no further scope to amend, modify and survive its own order and pass any order afresh in connection thereto. In the light of the settled provision law, the London District Magistrate became functus officio. Thus, the impugned order dated such and such are unlawful and bad in law. Both the impugned orders have been ambiguous that out of two. It appears that the DM passed the orders mechanically without application of mind. This is second. Controversy regarding date of classification of the account as NPA as alleged made on such and such date is kept open to be decided at time of final hearing. So it is also open. Prior first year operation of the impugned order such and such passed by the London District Magistrate is allowed. Respondent bank is restrained from taking any coercive steps in respect of the secured property on the basis of the impugned order dated 6 October 2023 and 20th November 2023 passed by the London District Magistrate. Fixed on suggestions date, this was fine. So this was subject matter of challenge. If this was subject matter of challenge and till such time this order, this finality is not reached. So far as the NPA, this is the basic criteria is on to your lordship. The date of NPA is at least 5 NPA date is there, which the London District Magistrate had taken into consideration. So until that is decided, whether the appellate court will pass an order directing execution. That is one of the points I am canvassing. Now, my lord, kindly come to which side?
So, Mr. Basu, your submission is when the NPA classification is under challenge in section 17, whether an order under section 14 shall be executed in the meantime. In the meantime.
Yes, in the meantime. Because that goes to root of the today, my lord, if I am dispossessed, everything goes, then ultimately what the bank will sell out the property, then ultimately what they will get. My lord, to that, if you lordship kindly come.
So, according to you, section 14 has to be resorted to after disposal of section 17 or after a final adjudication of a dispute in section 17 challenging the NPA classification or the measures under section 13.
I can go to that extent if I can satisfy the court that the basic criteria for invoking section 14 has not been properly done. In that case, in all cases, I thrown a challenge. There is nothing. A prima facie. Whether that will wait till such time, or in a case where I made out a prima facie case to decide, these cannot be equated. One thing is clear, NPA is a sine qua non to it.
Mr. Basu, does section 14 contemplate an adjudication with regard to
satisfaction? Satisfaction.
How? What satisfaction?
He has to look into that paper. That what is the date of NPA?
Then,
now I show to you.
Mr. Basu, please come to section 14 proviso. Please read proviso.
Provided further that on receipt of the affidavit from the authority.
No. First proviso. Provided that any application prior to 9 point. Yes.
Application by the secured creditor shall be accompanied by the affidavit affirmed by the authorized officer of the secured creditor.
Declaring that. Yes. What are the declarations as you have placed? 4
and 5.
Yes, 4. Please read 4 and 5. 5. Yes.
Consequent upon such default, in repayment of the financial assistance, the account of the borrower has been classified.
He will only required to state on affidavit that consequent upon the default, it has been classified as NPA. And if that statement is there, district magistrate or any other authority under section 14 cannot go beyond.
I have given an example. This suit court judge, I can give an example. Your lordships can recall, previously it has been said, the plaint has to be looked into for orders on 11.
Please show me on section 14. Mr. Basu, don't go into the plain.
I am going to instance. Now, what if I
order 7, rule 11 concept is a different thing also.
Allow me, then I can make what is passing to my mind.
Yes.
The 711 plaint case is gospel truth. If I say in the plaint the sun rises in the west, it is the gospel truth. That your lordship has now modified. No, the court can look into the documents annexed to the pleadings. To substance of the pleadings, court can go into it. Now, my lord, I am saying, it is merely saying it, not for saying. What for then DM is necessary? DM has to apply his mind and to see what has been stated is correct or not.
Show me the scope of the authority of the DM or an authority under section 14. What is his power and scope?
He cannot adjudicate. I go to that extent. But if I say something incorrect, then, my lord, what is the necessity of this paraphernalia?
Mr. Basu, DM is also not authorized to make any comment on that. If an authority is not authorized to make any comment on that, can he make any observation on that?
Lord,
as per the statute?
Kindly go to the other way around. What this is to be placed before the DM? This can be placed before a fourth.
It has been considered times and again by the Honorable Supreme Court in a catenary of judgments.
Right. But everywhere it says, if you say something which is incorrect on the face of it.
Please show me any decision which says that if these statements, an authority under section 14 has a duty to verify or vouch its authenticity or...
Satisfaction is that he has to be satisfied.
Show me that. Show me the decision. Show me the statute which says he has to be satisfied with that.
Language is there.
Yes.
Provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the sergeant said, as the case may be, shall after satisfying the contents of the affidavit.
Yes. So contents of the affidavit, it has to contain these 9 points. Not satisfaction with regard to the merits. satisfying contents with regard to.
Probably, my lord, that petition. Then, my lord, I will be submitting. Then, what is necessary to place it to the DM? It can be sent it to the class 4 staff. He has to count 9. Yes, 9. Whatever are there. Suppose, my lord, the language what is to be given without giving 9 points has been given. 9 ABCD, 9 names has been written.
Mr. Basu, kindly see the next part.
Yes.
After satisfying, what he can only do.
Contents of the affidavit.
Yes, what he can only do. Pass suitable orders for the purpose of taking possession. That is the only requirement. He has to, cannot do anything more.
I repeat well. But for this satisfaction has a different connotation. What's to be satisfied?
Do you have any authority in your support that he has to
always,
DM under section 14 has to pass record his satisfaction?
My lord is always insisting on authority. The language in the statute is clear. Satisfaction has a different connotation. What to be satisfied? Only 9 numbers. Only 9 numbers will do. Without what has been asked for in these 9 conditions. Instead of something else has been written there. PM is not looking to this. Am I clear to my lord? DM has to satisfy himself that contents were there to that extent what is permissible. Suppose clause 4, instead of saying no NPA, say no NPA. Suppose you will pass an order under section 14. Why not?
That is the requirement.
Yes.
Mr. Basu, it says it has been borrower has to state on affidavit,
right?
Because that is the requirement. Affidavit on oath he has to say.
He has to look into the whether affidavits are in the form or not.
Yes, has to be on the form or not.
Can you test my submission? If he says in paragraph 4, no, up till now there is no NPA.
Up till now there is no NPA. Then cannot be done.
Why not? If he has
because
to satisfy himself.
Mr. Basu, because it requires has been classified. If he says on oath it has not been classified, then this.
Well, I could not put myself there. May I repeat? This is required and mental thought of the DM, not counting 9 clause.
No.
So if
not. I did not mean to say only 9 will be counted.
So he has to apply his mind.
Yes.
So if he applies his mind, if I say something which is not really true, really not there, even then, my lord, he will pass an order under section 14.
Yes.
That is, my lord, it is stretching too far. Section 9 point, he has to apply his mind and to satisfy himself. That is the language used in the provision.
So according to you, satisfaction with regard to this point number 5.
All points.
So you are restricting on point number 5. So far is your case.
NPA. Now, my lord, kindly come to.
So satisfaction of DM or section.
Who are exercising power?
DM with regard to paragraph 5.
Now, my lord,
is necessary.
Yes. It is application of mind necessary, not adjudicatory, not the adjudication.
As such, satisfaction of DM. I have used that expression only.
Satisfaction means mind has to be there.
Yes.
Now, my lord, kindly come to 163.
What?
163.
Page 163.
This is the order which was passed.
Order passed in 14.
This is the order, first order. This is the order dated 6.
Under 14?
Yes. 6
yes.
For 2020.
So this is the initial order.
Yes.
Yes.
Well, kindly come to 62. First, kindly come to 62. First, second, third. Whereas from the documents and status report submitted by the authorized officer, it appears that the secured creditors granted a loan of rupees such and such only on 28th of April 2024 as borrower during it was such and such. Page 35 minute I am marking why this case 35. Just a minute.
Mr. Basu, do you have your application under section 17 challenging these 2 orders?
Which 2 orders?
this 6th of October 2023 and the subsequent modified order or two orders, what you are saying. So take it at that. So where is your Sarfaesi application challenging these two orders?
Kindly come to page 35. Limit is 300 lakhs. Page 35.
Page?
Page 35.
This is that application.
No, this is the my sanction letter.
Sanction letter.
Limit.
Yes. Yes.
Second column 300. Seen that second item. Name of the
300 lakhs.
Yes. Now kindly come to 162.
162. Yes.
308 lakhs.
Yes.
So the papers which was placed before the Section 14 authority is based on wrong calculation, wrong thing. I've shown you the sanction is 3 lakhs and it is set at 3.8, but from it has come first. Then we can put 3.8.
So that is why, Mr. Basu, so Section 14 at no point of time can be resorted to prior to final adjudication of Section 17, challenging the measures under Section 30.
I am not going to that extent. I know my limitation, how far I can go. Now I'll come to 163, another thing. Now the NPA. Second, and notice dated 20th November 2020, 13.2. Demanding payment of default amount was served. On the defaulting borrower, they obtaining a lower 273.52. It is much below the sanction limit, so there is no NPA. NPA has to be over. The authorized officer of the secure authority devised to receive on representation that has been considered. I am not going to that extent. Only consideration will do. That has been considered in page 151. So, my lord, if there NPA, the one thing is that the both order cannot stand together.
No, Mr. Basu, I could not get you this point. Loan was sanctioned assuming of 3 crores or 3.08 crores, whatever it might be.
Yes.
So for a default of
Default is 271.
So NPA cannot be done.
Cannot be done.
Why?
Because it is below sanction limit. It is below sanction limit.
Loan, Mr. Basu, if there is a default in payment of loan, no NPA. It has to be above that.
No, this
loan amount granted, portion of that repaid, balance you are not repaid. No NPA.
Current account was there. Current account was there. I will show you how many.
That is a different thing altogether.
So that's why
Mr. Basu.
This cannot be NPA. Because I have told you how many NPA is there.
See, Securitization Act 2C. 2C, the definition of NPA is given.
Yes, I know.
You know, I know.
Allow him to make his submission in his
come to page
own way. Yes, page.
Page 45 is the first NPA. 29th June 2018.
Yes.
Now, my lord, second NPA. 29th May 2019, page 47.
Yes.
NPA, my lord, my landed friend's client is relying on. Which one? So kindly come to 47. It's another NPA. This NPA, 13-4 notice was given, page 51.
Yes.
Kindly come to page 51, possession notice given.
Page 51.
Possession notice was given.
Yes.
13-4 invoked. Then, third NPA, on my lord, 3rd February 2020. There was stops there. Fourth NPA, 10th December 2020. Page 116. 13-2 notice issued. And again 13-4.
Yes.
Can you see that again 13-4. Page 54.
Yes.
This was challenged in essay. Page 54.
Page?
I have shown to your lordship page 45. Thereafter.
Yes, that I've seen. Then
now
first,
third NPI is third.
that I've seen. Thereafter, you are trying to show.
Fourth NPI is 10 December 2020.
Yes.
And 13 notice was issued on 6th April 2021, page 116.
116. Yes.
Against that, my lord, 13th notice issued on 23rd June 2021, page 54. That is subject matter of challenge.
Page 54.
My lord.
That is the subject matter of challenge in
section 70. 70. Thereafter, my lord, then my lord, 5th NPA. That your lordship will get at page 132.
Yes.
So accordingly, my previous section 17 application became infructuous. My previous section 17 application became infructuous. Because, my lord, there is.
I will record your submission that it has become infructuous.
Yes, infructuous. Has to be. Because thereafter 13.4 again issued. Which is now, my lord, is considering. That is, my lord, 5th NPA on 20th November 2022. That is, my lord, at page 132.
132, yes.
Then 13.4, 14th February 2023. That was challenged in section 17 is pending. So according to my lord, my humble submission, the district magistrate, while exercising power under section 14, was unaware of the date of NPA.
Aware of?
Unaware of the date of NPA. Because my lord, shown to your lordship, my lord, so many NPAs. If that is not there, but it goes to the root of the matter.
Mr. Basu is the borrower entitled to an opportunity at the section 14 stage.
No. No.
So it's only the documents which are being produced by the secured creditor. On the basis of that, DM will proceed.
That I'm asking from the very beginning, is it sacrosanct? If documents.
Mr. Basu, the analogy which you are trying to bring from section order 7 rule 11. In order 7 rule 11, what happens? Even going by the settled proposition that the statements made in the pledge has to be taken to be gospel true, but there the defendant comes. Defendant has a right. He can take out an application. You may say no. Even the statements in the application cannot be looked into.
Yes.
Only statements in the application cannot
be
looked into. Only the plaintiff has to be looked into. But the defendant has a right to point out from the plaintiff that look, these are the.
I am grateful to my lord. Here, the case is not that this defense should be more cautious.
Yes, yes. But question is, how can you now challenge when at a subsequent stage, because the DM has passed an order on the basis of a document, merely on the basis of that affidavit, statements in the affidavit, no other document is coming forward before the authority under section 14.
That's why the trial judge, the lower authority, my lord, passed an order that the question of NPA.
Mr. Basu could not have, because the DRT, while deciding an order under section 14, could not have expanded that scope, could not have looked into any other documents.
But that is
not
that is
the way of expanding the scope of that section 14 order, Mr. Basu.
Two things was there before the authority, the lower authority. One is the two order cannot stand.
That is one thing. That is one thing.
That the basis of going to NPA is the sine qua non for exercising power. That is not there. That is disputed. Because I am not saying that is my document.
One of the principle is whether the authority or the court also, what we are trying to say, whether he was right or wrong by passing an order on the basis of the materials that were available before such authority.
In a case,
so what was available was only that affidavit, nothing more.
Right. In a case where the other side is not there.
So in an appeal,
the court.
Mr. Basu, in an appeal, yes.
Can I recall the ex parte decrees? court are more cautious when passing an ex parte decree.
Yes. Ex parte decree, yes. So what are to be satisfied? So ex parte decrees, those conditions, enabling the plaintiff to get a decree or not,
My lord, your
only
lordship has
those.
in a lordship lifetime saying so many ex parte decree, plain dismiss, suit dismissed.
Yes, yes.
So it is
It's not that ex parte means it has to be decreed.
that I am
Not
saying.
that. So
Magistrate, my lord, has to look into the fact. He is not mere, my lord, looking into this. He has to apply his mind, has to be satisfied. If he is not satisfied, my lord, his exercise is wrong.
there is also a difference, Mr. Basu, there. In that ex parte decree, the evidences are also to be produced. So court has to, not only to the plaintiff, but also.
I am looking, sir.
But
that the
here
document-
there is nothing, only the affidavits, nothing.
Which are documents there, he has to see whether the documents are in accordance with the requirements.
Yes.
This much he can see.
Yes, yes.
He has not seen. He has not seen because I have shown to your lordship, my lord, there are at least 5 or 6 NPAs which he has taken consideration, and I have shown to your lordship this is the document which has not been considered to be an NPA.
But is there any supporting document which is to be produced?
Only one document I can produce now.
Do not have any 330 today. No communication has come to me.
I have the communication, I can produce.
You are not the office bearer, Mr. Basu.
When I was bearer, I was always bearer. Well, any day other day when it suits my lord.
That is the difficulty, Mr. Basu. This side of the vacation.
Today I am my lord,
really
totally handicapped. I have 2 juniors in this matter. Mr. Siddhartha had just come, but he fell sick, left.
So now I find some submission was made that these fixed matters are not being taken up. This is the second fixed matter. First fixed matter could not be. Mr. Chatterjee was there. He paid for an adjournment and went. So it's very difficult.
Not you, Chatterjee. But at least I have not made that fault. Not paid for adjournment.
No, adjournment was paid for.
Yes, yes, because none is here. Mr. Kaur is also with me. He is not in town. Mr. Siddhartha Banerjee.
But only difficulty is I do not know when to fix it prior to vacation. Because motions are there, that is the only difficulty. And today I could have continued, but I have to deliver one judgment. I have to do it today itself. That is,
their interim order is up to 31st of May. I am opposing for extension of interim order. Let them pay something.
But Mr. Chatterjee, it's being hard. It's being hard. Only difficulty is that the difficulty is on the part of the court. I cannot fix another day. You have concluded Mr. Basu is in the midst of his hearing.
He is making. Well, let him make his submission. I will not make any comment on his submission right now.
Interim order is still till the end of May.
Till the end of May.
So I'm extending it till the end of June.
No, not end of June. Your lordship may kindly extend it till 2 weeks after the vacation.
I'm keeping it, Mr. Chatterjee. I'm keeping it immediately after the vacation, but I'm extending it till the end of June. I'm keeping it immediately.
They are enjoying the hotel. They are not paying payment of money. It was when
Mr. Basu, how long you will take?
Not much. More or less.
Give me an idea about. You have made your submissions.
More or less. Half an hour more.
Half an hour.
At maximum. Outer limit. Outer limit. I may be prior to that. My lord knows I am not always I always try to be brief.
Then, my lord, when Mr. Basu is taking half an hour, I have concluded I may take 5 or 10 minutes.
Because you have a chance to give a reply. Because
Around.
it's the other way. Because he has started, you are not there.
So what? But to adjourn this matter, like other matters.
Ashwin.
It's
difficult.
Line
because
he has not seen the queue here. That's why he is saying this.
Please, I request you to come next Wednesday in the morning. Please come.
Then let them make some payment.
That
Payment,
is,
how
some payment, how can I direct now? here?
Whatever they have admitted, that is their dues. Whatever, let them pay that. I am not asking anything more. That is
What is your admission, Mr. Basu?
that is their admission.
Remember now. But only I had a talk with my client. If he, I'm telling you frankly, if he get 1.5 months more, he will pay the entire dues.
No. How much more? How much time?
1.5 months.
1.5 months.
If he gets that, I have a talk with my client, then he will be able to liquidate the entire amount.
Now, your lordship, can you see his admitted amount is this. His admitted amount is this. He has said this is the amount. He has taken loan.
Yes,
but
loan I have taken admitted. How can I deny that?
Yes. So that is 3 lakhs, 3 crores, 3 crores, 3 crores.
I'm also so. Please say it in lakhs.
Mr.
No difficulty on that.
Crores, everything.
Who said so?
I don't.
I'm not used to crores.
I don't have. So, and your lordship knows me. Your lordship also sits in court route number 11. So we are known to each other. At least at the time of in the bar, not at this stage.
So I can make that. It will be open to make that admitted amount.
Your lordship, your lordship.
Admitted. It will be open to the.
That is always because I have taken loan.
Open to you.
Yes,
it will be open.
Your lordship, can you record that at least for my safety skin?
দেবেন না, তা মাঝখানে দিয়ে দেবেন।
My lord, Mr. Devashish Saha, State Bank's
But
advocate is here.
not that the out of 4 crores, let them pay 40 lakhs. That will not be suffice.
My lord, my other side is present, my lord, any day be fixed, my lord.
1 minute, Mr. Adhikari. Mr. Rai, that judgment
Whether will be appear in court
in court.
at 4. 4:30.
Now it's 3:40.
No.
So I think it will take 4:30.
4:30.
In between 4:30 to 5. Yes.
Any day, my lord, any day, my lord, any day for the
Hearing has been concluded.
No, my lord.
Says he wants to make some.
Because there is some
What time?
net problem.
On any day that in the second half, preferably in the second half. They will accept Friday, my lord, because I have a matter fixed on Friday.
এটা ওই ফাইলে রেখে দেবেন, চ্যাটার্জির ফাইলে।
Yes, my lord.
যে ম্যাটারটা এক্ষুনি হলো
CO, that is CO 1354 of 2025.
My lord, difficulty is that my lord has requested us not to take any coercive action in the meantime.
that is why I am all right. এটা একটা কাজ করুন, সোমবার দিন টিউসডে, because if I have to hear, I have to pass an orders. I fix a date on Tuesday itself, my lord.
To be mentioned. Get it.
Where is your other side?
Online.
Yes, do you have any objection to that?
Yes, my lord, this is a civil revision against an order by the arbitrator for jurisdiction. Let's the next day, my lord will decide.
Saying you can, nothing prevents you from making an prayer for adjournment. Make a prayer. Let it remain. You can make a prayer. They will contest. Till our honorable judge will take a call on that.
I'm so grateful.
In the morning, your lordship asked me to call a person.
Yes.
I called him twice, but I don't know if he has come. I'm just.
All right. ওটা আবার রেখে দেবেন, তুমি মেনশন নেই।
Item number 47 for judgment.
Maintenance. Oh, the book. Whose book is this? Wait a Ferot. Huh? Thank you. You will get. Wait for half an hour. Because it will be.